I'm just teasing.
All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston, within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
That's better. Good morning. Welcome to the October 4th, 2023 sitting of the Massachusetts Appeals Court. I'm Justice Eric Neyman. Sitting to my far left and appearing by video conference is Justice Vicki Henry. Sitting to my left is Justice Joseph Ditkoff, and we will be your panel for all 6 cases this morning. Usual appeals court rules are in effect, which means each side has 15 minutes to present argument. There is no rebuttal. I can assure you that this panel is very well prepared. We have read your briefs. We have read the record. We will have lots of questions. So I urge you not to delve into the facts, but to get to the heart of your argument. However, your 15 minutes is yours to use as you see fit. 2 final notes. One is we go by the clock. You have 15 minutes, and when the red light goes on, that means your argument must end. If we need to give you more time, we in our discretion will do so. Final note, on occasion you will see the judges looking down at our iPads or our computers. I assure you, we are not reading email, we are not reading the funny pages, we're certainly not reading about the Patriots these days. What we are doing is we are checking the facts, we are checking the case law, and we are checking your representations in the record in real time. You have our full attention. So with that, we'll call our first case, Commonwealth versus, I believe it's Galini? Galini, and it is docket 22P1034. We'll hear first from counsel for the appellant.
May it please the court. Thank you, Your Honors, for giving me opportunity to address you regarding my client, Mr. Gaglini's appeal of his conviction. As you know, I have 2 arguments in this case, in my brief. The first one is that the judge should have allowed the motion for required findings because there was insufficiency of evidence, and there were 2 subparts. The first subpart was that the touching was not indecent according to the standard provided by Commonwealth versus De La Cruz and Commonwealth versus Jarrett. Second subpart was that the Commonwealth failed to prove that it was non-consensual touching, and allied with that is that there was no intent. There was no general intent that was proved. The second major issue was that the judge should have provided a curative instruction about the emotional testimony of the alleged victim or the victim, and that failure was a miscarriage of justice. So I will go to the first argument, first subpart, whether it was indecent, whether it fit the Commonwealth's definition of indecent. I would suggest to you that that standard is common understanding and practice from the Commonwealth versus De La Cruz. My client the defendant had testified that this was the preferred way of teaching a student driver. That was by touching them rather than stepping on the brake. I don't know if you remember your student driving days, I do, and that the stepping on the second brake was very terrifying, or it was, could be jarring. And so he had testified, the defendant had testified, well, this is what he does, depending on...
My instructor hit the second brake within the first 2 minutes.
I'm sorry?
My instructor hit the second brake within the first 2 minutes for me.
I'm sorry, I didn't hear what you said.
I'm sorry, I just said my instructor hit the second brake within the first 2 minutes for me.
Yes. Mine took me on the highway, so I was pretty terrified. There's no reason to believe that this was not the case, that this was not what a standard driving teacher would do. Both Mr. Gaglini and Feely testified that this method was used as instead of the brake.
It would be one thing if there was testimony only that your client touched the young man's shoulder or knee, but he touched him, at least according to the so-called victim's testimony, above my groin, my thigh near my groin, did it multiple times. He touched me right here, but if my penis was on this side, he would have touched it over 20 times. That strikes me as a little bit different than at least what my driving instructor did.
Fair enough, but you're getting into my second argument, but I certainly will tell, I guess they're sort of joined together. My answer to that, Your Honor, is that the context is very important, and I think that it's reasonable to understand, or you could take judicial notice, that they were in a vehicle, that they were in a confined area, and that if he was any good instructor, his eyes would be on the road, and he would be touching the person, not knowing where he's touching. The question is...
Once makes sense. 20 times is a bit more of a difficult fact for you to overcome, but go ahead.
Well, the answer to that, Your Honor, is that Mr. Feely had said, well, I was a very good driver, while Mr. Gaglini said that he was not a very good driver. And I would suggest to you that after being 7 years of instruction, he would know, he would have a better guess about whether or not the person was a good driver or not. And so therefore, I would say, he had testified, the instructor had testified that it was only 5 times, it was not 20. But in the best light for the Commonwealth, saying that it's 20, I would suggest to you that it was because of the poor driving of Mr. Feely. Not only that, though, added to that, or more importantly, is that Mr. Feely had testified during his examination, direct examination, that he didn't that he didn't object during the time that it was occurring. He only objected afterwards, when he had some time to think about it, perhaps, or whatever. But he didn't at that time say that he objected to the touching of Mr. Gaglini, or thinking that it was indecent. So therefore, Your Honor, I would suggest to you that it was not indecent. The other issue regarding this is that, as I said, it's context, that he knew he had, they were driving together. The cases that my sister
But counsel, why is that not an issue for the jury? They've got the testimony of both the defendant and the student driver, and the student did demonstrate where he was touched, and he specifically said at least one time it was on his groin. But why is that not the end of your argument?
Because, to answer that, Your Honor, it's a good question, but the answer to that is any question with motion for required finding. The question is whether or not it was insufficient evidence or not to go to the jury. I would also add that when...
Right, but why is that not, that's what my point is, why is that not sufficient to take the question to the jury?
Because if you look at the...
He's testified to an indecent touching, that it was on his groin. Putting it in a different context, if a driving instructor put his hand on a female student's breast, nobody would say, oh, she didn't object, so it was consensual. That would just be, nobody would ever make that argument. So why is that not sufficient to go to the jury?
As I was saying earlier, Your Honor, it's a good question, but I think that the answer to that is that the student driver did not think that it was indecent at the time, did not object at the time, that it was, the question is whether or not the person had, Mr. Gaglini had knowledge of what he was doing was intent, that he had the intent, that he was touching him. His eyes were not, he was not staring at the student driver. He was watching the road.
So go back to my question. Can intent be inferred by the fact that the same action, according to the victim, was conducted 20 times?
I would say no, Your Honor, because, I mean, the point that I'm trying to make is that he was trying to, he was doing his job and he was touching the person to tell him to slow down. And if he was looking to where he was touching, then his eyes would be off the road. That's something that would be, that's judicial, strike that. In any case, to back up the Commonwealth's argument, they present two arguments, two cases that, for example, Commonwealth versus Lavigny, and that on its face might seem that it has something to do with this case, but it's very obviously distinguished in that it was a hitchhiker who was picked up. It was the victim was propositioned for sex, but most importantly is that, and I think that this is something that I should have said earlier, was that this that the victim here in our case was in control of the vehicle. He was driving. He could have stopped the vehicle at any time. He could have made a protest. He could have gotten out. He was in control, as opposed to the victim in Lavigny. Also, we have, they give Commonwealth versus Biano, in which there was a 13-year-old girl who was, as you know the case, the hand was on the breast for 5 minutes as opposed to 10 seconds. Even though, now, I understand what you're saying about being 20 times, but if he was making 20 different errors, that would not be out of context. It would not be under the, it would still fall under common understanding and practices. So I would suggest to you also that there was consent. He knew before getting into the vehicle that that this man would be touching him. He knew that if there was some errors that he would be touched. And also, so I also think that, to answer your question more directly, Justice Henry, is that Mr. Feely had a presupposition before getting in there that he was, that the defendant was weird, that he was saying things. He had this presupposition that there was a sexual content in whatever Mr. Gaglini did. And it was interesting that he never protested during this ride. For example, he says, I believe that there was testimony that said, Mr. Gaglini said, let's have fun. Let's go crazy today, or let's have fun. Of course, in the context of showing a student driver, I mean, that's what people want, students want to do, is they want to learn how to drive. He looked at it as something sexual. He said that it was weird that he would want to give him a lift home. I mean, that's what he did, according to Mr. Gaglini. That's what he did with all the student drivers, and it would seem to make sense that you would drive the person home. But he's looked at it as a weird thing. He also said that during the conversation, it was a normal conversation. There was nothing, no innuendos, no offer, no proposition. So I would suggest to you, Your Honor, that that there was. He said, "Let's have fun." That's what I mean, that certainly is in the context that certainly would make sense. He also said that Mr. Gaglini had spoke to him with a sexual tone. He wasn't able to really explain what that was. I would suggest to you that by over-sexualizing everything about Mr. Gaglini, it is likely that Mr. Feely overestimated his testimony about the amount of times and location. And I would suggest to you that that was what that the judge should have taken that into account when deciding the motion for required findings. There was also kind of interest, it's not in my brief, but I also would like to point to you that...
Could you explain that to me? You seem to be saying the judge should have found the victim not credible, that he was exaggerating, and that his testimony shouldn't be found credible. But how, under what circumstances can the judge do that in a sufficiency setting?
Well, you're right. I don't think that it should be the credibility, but just looking at the facts of the testimony that they're giving, that it colors the entire thing that Mr. Feenley has said, because he just went in there knowing, thinking, or believing that Mr. Gaglini was going to do something wrong, and so I would suggest to you that the judge should have kept that from the jury. The other issue that I have that goes along with this is the emotional outburst.
I have a preliminary question about that. You say in your brief that trial counsel objected to this. I'm looking at the trial transcript, page 89, and I'm not seeing any objection to it. And I don't see any request for a curative instruction.
There wasn't a request for jury instruction.
I also don't see any objection to the witness. You say there's an outburst. I don't see any reference in the record to anything other than the judge saying...
He said on 88...
All right, do you want to take a sip of water? If you want, there are some tissues to your left.
I have on page 88, Your Honor, that he says, how do you feel? Objection, overruled, embarrassed.
What line
Why did you say that? Objection, I'm sorry.
I'm sorry, what line?
88 on...
Line 16.
from 13 down to 25.
He said, how do you feel? Objection, overruled, embarrassed. My understanding is you're objecting to the quote-unquote outburst.
I quoted in my brief, Your Honor.
Is the outburst touch me like that?
I'm not sure which. Let me see. Oh, I have it over here. I believe that, on page 29 of my brief, Your Honor, I quote it, but do you remember if you were crying at all during the phone call with his mother? Inaudible. Sorry. He said, yes. Why are you crying? Were you crying? Inaudible. Notice that you were shaking today. How do you feel today? I'm cold. How else do you feel? Objection. Court overruled. Embarrassed. Witness embarrassed.
So what exactly are you arguing? Are you arguing, you mentioned the emotional outburst, which I assume you're inferring. By emotional outburst, you mean that the victim was shaking and appeared to be, at least have tears?
Yes, Your Honor. My objection is that, or what I feel is that, I guess you'd say my objection, is that it was the embarrassment or the crying or the emotional outburst was a present emotional outburst, not describing the past, not what was going on in the past. He wasn't describing the...
Your time has expired, but please keep going.
Sure. That he was, as I put it, I think that it is also an argument with the emotional with what the prosecution had said during this closing argument. But at the time of the testimony, he was testifying, his crying, his emotional outburst was the present-day embarrassment, not describing what occurred in the past, was not providing a memory. It was the same as if you're saying, were you in fear? No, I wasn't in fear then, but I'm in fear now. And so,
do you agree that the standard of review for us on this issue is whether there was error, and if so, whether it created a substantial risk of a miscarriage of justice?
yes. And I think that's tempered with that at that point that the judge should have added to this, the judge should have allowed
Given an instruction, but none was requested, correct?
That's right.
Okay, before you go, let me check Justice Ditkoff. Anything further? Justice Henry?
Good, thank you.
Thank you for an opportunity to address you. Thank you.
We'll now hear from the Commonwealth.
Good morning, Your Honor. Sarah Lewis on behalf of the Commonwealth. We're asking this court to affirm the defendant's conviction for the indecent assault and battery on the victim in this case. Turning first to the sufficiency of the evidence, the trial judge here correctly denied the motion for a required finding of not guilty, where the evidence sufficed to show that the defendant here indecently, intentionally touched the victim without his consent. With all due respect, I think the primary problem with the defendant's argument is that he fails to consider the evidence in the light most favorable of the Commonwealth and pulls in a lot of the defendant's own testimony regarding where he might have touched the victim, regarding alleged standards of driving that only were presented through his own testimony and no other evidence. This is a case where a 65-year-old driving instructor, while inside a moving vehicle with a 16-year-old first-time driving student, repeatedly touched him on his leg, where his leg met his groin area. As your honors are aware, the touchings ranged from a tap to 10 seconds long and happened over 20 times, again, in the light most favorable of the Commonwealth. The behavior shocked the victim. It made him feel uncomfortable.
Counsel, there were two charges. Do we know, is it for the touching of the groin or is it for the hug that there was a conviction?
It was the complaints, Your Honor. The first complaint was, quote, touching Eugene Feely's inner and top of his right thigh. The guilty conviction was for that complaint. The second complaint was for touching the area above the victim's groin, the abdomen area, as I think it was more aptly described by the judge when there was a discussion on this issue. And there was a not guilty on that charge. So the guilty here was on the touching of the leg area, and as the victim testified, his leg where it met his groin area.
And there were explicit, specific verdict slips in this case, correct?
There were, yeah, which I think helps clarify. And those verdict slips, as it is made clear on the record, tracked the language of each complaint, and that was agreed to by each party.
But do you agree that here through cross-examination, the student driver ended up testifying as to where the instructor said he would touch the student if there was an error, and that it was that practice was to touch him in an area that would not have been an indecent assault and battery, like just, around the knee or somewhere more innocuous?
Yes, I do agree with that. There was some confusion on direct. There was questioning about where the demonstration took place. That testimony was that it was on his arm near his elbow and on his knee. Then when the prosecutor asked him to demonstrate that, the victim demonstrated where the touching actually took place, and that was in my interpretation, or the Commonwealth's interpretation of that, was clarified on cross-examination, where the victim clarified that the demonstration wasn't what was inappropriate, it was what it actually occurred, which was inappropriate. I think that goes to the issue of consent, and I would like to just clarify, and I would point to the court. I would point to Commonwealth versus Shore 65, Mass App Court 430. It's cited in the Commonwealth's brief for the fact that a defendant doesn't need to, a victim does not need to physically or verbally rebuff advancements by a defendant in a sexual assault case. Here, the victim testified that he did not consent to this. He also did not verbally say no, but that is not required under the law in this Commonwealth. So there was a lack of consent. The evidence sufficed to show that, as well as the fact that the touching here was intentional and indecent. If the court has no further questions on the sufficiency claim, I will just clarify.
Well, I did want to ask
Yes.
one question. The defendant summarizes the evidence on page 18 of his brief, and I was not entirely clear if the Commonwealth fully agrees with that summary or felt it was unfair.
I'm just going to briefly turn to page 18, Your Honor.
Sure, he's got it all
Yes.
dashes, single-spaced.
The Commonwealth disagrees, broadly speaking, insofar as it's not listed in the light most favorable to the Commonwealth. And therefore, in terms of a sufficiency claim, it is not the correct lens through which to look at the evidence. I can certainly go through each bullet point, but that would be my general response to the summary of the evidence there. And also, I do disagree with to the extent it's specifically listed there without going through it right now, but I do disagree with the interpretation of the demonstration because, as we discussed, it was clarified through the victim on cross-examination that the demonstration was occurred in one way and the actual touching throughout the driving lesson occurred in a different way. Regarding the judge's failure to sua sponte give an instruction to, for the jury how to assess the victim's demeanor on the stand, I would just say that this fails factually and legally. Factually speaking, to Justice Neyman's point, I don't think the record supports an emotional outburst on the stand. It shows that the victim was shaking. It shows per his testimony that he was feeling embarrassed. And by the judge's...
I understand, look, witnesses shake on the stand. Juries can see that. So I don't see any harm from the question. I noticed you're shaking today. Might not have asked it, but the follow-up, how do you feel today? How is that relevant?
I think it's relevant because a victim's demeanor is relevant. And I think we weren't in the...
Demeanor is relevant. Their commentary on how they're feeling on the day they're testifying, how is that relevant?
I would step back and just and say that having not been in the courtroom at the time, it seemed like this was a line of questioning in response to what the victim was outwardly showing on the stand. In terms of how are you feeling today, perhaps that question was better left unsaid in terms of the today, but the fact that he was feeling embarrassed and that the prosecutor then discussed in closing, and I would say properly so, the victim's demeanor on the stand is entirely relevant in a credibility determination, specifically in a sexual assault case. And so I think that for the judge to have instructed, as the defendant's now requesting, would have been improper. I will say, though, that the judge did instruct, per standard instructions, at the close in her final charge, that the closing arguments are not evidence, that the jury is to set aside sympathies and prejudices, and to not decide the case based on likes or dislikes. And I think that to the extent there was any error here, there was certainly no substantial risk of a miscarriage of justice that arose from it.
Counsel, we do agree that the victim was crying and having trouble answering the question whether he had been crying before. I mean, the record reflects that. You agree with that?
Yes, the judge offered him, in terms of the judge offering the victim tissues, would suggest that he was crying. Right, and I agree with that. I think that to say it's an emotional outburst perhaps reads too much into the record, particularly where the defendant did not object to an emotional outburst, and I think that speaks to the tone and manner of what was happening at the time. I will just clarify, there was an objection to further questioning about on page 88, there was an objection that was overruled, then a further objection that was sustained to asking further questioning on that he was feeling embarrassed, but there wasn't, as you pointed out, Justice Neyman, an objection to an emotional, outburst. So therefore, this would be reviewed for a substantial risk of a miscarriage of justice, of which, as the Commonwealth argues in its brief, there was none.
I have one technical question.
Yes.
I assume there's no prejudice to the Commonwealth from the premature notice of appeal by the defense.
No, and that was resolved, I believed, below by the court, accepting the notice of appeal late, I believe. I believe it was a...
That's what the judge ruled, but it was actually quite a bit early, but...
Okay, well, I don't...
No prejudice, right?
I don't believe there is any prejudice. And I think it was tied to sentencing and other considerations below following the conviction.
Yeah, I'm certainly sympathetic to defense after getting continued over and over again for disposition saying, I'm going to file it.
Yeah, understood.
Justice Ditkoff, Justice Henry, any further questions? Seeing none, thank you both. Very helpful arguments.
Thank you very much.
The case is submitted.
Thank you.
Calling our next case, Commonwealth versus Michael Hand, docket 22P1132.
Just for clarification, which of the Michael Hand appeals is first?
This is docket 1132. Let me just check my...
Suppression.
Suppression? Okay.
We're doing suppression first.
Okay.
1132 is the cat out of the bag.
Just need to know where to sit,
Case.
yeah.
That's why you sit there for this one.
And Appellant Commonwealth, whenever you're ready.
Thank you. Good morning, and may it please the court. Kaylin Campbell on behalf of the Commonwealth. We ask you today to reverse the allowance of the defendant's motion to suppress statements he made to his pastor. I'll start with the caveat that this is an unusual case, and that the first issue that the Commonwealth raises is an unusual way to raise the issue. I think had this case been litigated in the motion to suppress stage pursuant to Rule 13, it would be a very different argument here. Rule 13 requires all known issues to be raised in the same in the same motion, and this case demonstrates the dangers when that does not happen. It's a very different calculus for the Commonwealth in determining whether to take a Rule 15 if certain statements they still believe are not challenged and will be admissible into evidence. I fully understand my sister's arguments as to the notice of appeal and as to the Rule 15 application. I just believe that I'd be remiss if I didn't point out that
Let's assume that we agree with you that there was a certain unfairness in procedurally how this went about. Was that argument explicitly made to Judge Davis at the time?
it was not. I understand that as well.
Problem, isn't
That
it, for
that
you?
is a problem. That is a problem, and I understand this could be opinion that reads, had you raised this claim below Commonwealth, this would have been a good argument. It doesn't change the calculus for this panel, though, which necessarily has to look at the suppressed statement because it has to look at the circumstances, the external circumstances which existed that caused it to become coercive, and whether those circumstances had been removed. So it could be an instance, and I do believe that that was wrongly decided. I don't believe there's anything involuntary about that statement that was made. I understand I'm stuck with the way that it was litigated below in all respects. But this court could look at it, say, too bad, Commonwealth, you didn't raise this, but there is no taint.
But we couldn't say that the suppressed, statements that were suppressed by Moriarty would come in, even if we thought it was wrong, right?
You couldn't. I think it does inform the analysis as it relates to the break in the chain of events and as to cat in the bag, because if there is no taint, if you find, okay, Commonwealth, you're stuck with this waiver argument. However, if there is no taint, then it isn't necessary to reach those two lines of analysis. Which is highly unusual, I understand. I think that this is a highly unusual case, both in how it was litigated and in the facts that are presented. I would like to spend the majority of my time...
But just to be clear, and really, I'd like you to join this rather than leave us to figure it out. It seems to me, or what I'd like to know, is the defendant correct that your application for interlocutory review covered only Judge Davis's ruling, not Judge Moriarty's ruling?
Correct. Judge Davis, though, takes judicial notice and says that he incorporates Judge Moriarty's entire ruling. And insofar as you have to consider the statement and the coercive elements of that statement, I think it is for this court to look at. Okay,
but you didn't make it expressly clear that you were trying to appeal Judge Moriarty's ruling, right?
The ADA who filed the Rule 15 did not. No, it was not me.
When I say you, I mean the Commonwealth. I'm not parsing between different attorneys.
Correct. But I don't think that changes the legal analysis that this court has to engage in, and that you necessarily have to look at that statement.
I know, but we need you to join the facts, okay? And I don't want to hear about excuses or variations. I just want to know the facts, because we have 30 minutes with you, 15 on each side, and we don't have time. So, is it correct that you didn't provide the video exhibit of his statement to the police to us as part of this appeal? Because I believe that is the case.
Correct. However, the transcripts are, and that leads me to the next point about the record. The transcripts are part of the record. I
Right,
think,
but now, I'm just going to say this, it's unacceptable. We have two parties who are telling us that the transcripts are different, but neither one of you seems to tell us exactly how they're different. And frankly, we don't need a puzzle to figure out. This should not be happening. You should be crystal clear about what the difference is, and you should be crystal clear, if it's the case, that the transcripts that the two judges had are different from the transcript that you provided us. There may be a reason, and I don't want to hear about that right now. What I want to know is there a difference, and what is it? As opposed to us just trying to, like I said, we have plenty of work without having to figure out what you already know and don't seem to be clearly telling us.
correct. I believe it's in my brief that Judge Squires-Lee made a judicial finding that the transcript that was previously provided was, there was an inaudible, and she found that the defendant admitted that he killed the victim. It's that inaccuracy that has been fixed in the
Is that
second
the
transcript.
only thing that's different?
There are some inaudibles. I'd say that's the critical thing that's different. Anything else that's different, I don't believe bears on any sort of analysis. I didn't do a line-by-line comparison. I focused specifically on that judicial finding from Judge Squires-Lee. I would note that there don't appear to be any difference in the part that's suppressed, which is the last 18 pages of that transcript. So insofar as it relates to this court's analysis, the Commonwealth has no objection to the court looking at the transcript that was provided by my sister and relied upon by Judge Davis. I think it's important
But
that...
we don't have the video to listen to whether he said, "I killed the girl," which is obviously an incredibly significant statement.
I don't believe so. That part that is not suppressed, that is not in the suppressed portion of it. I also don't think it changes the analysis as it relates to, and, you know, I didn't rely...
Well, but this is where I'm back to what's the record before us, because we are reviewing a ruling of one or maybe two judges who are not Judge Squires-Lee, but you're telling us we should rely on a factual finding from Judge Squires-Lee, right?
The factual finding is indisputably in the record. It's indisputably on the docket. It's indisputably in a decision. I don't believe...
But it wasn't made by either of the judges that you're trying to get reviewed here.
Correct, and I don't think it's critical or necessary for the analysis that this court has to engage in. If Your Honor wishes to strike...
Well, if we're looking at the state of the evidence, right, my understanding, and you tell me, but I didn't feel like there was a clear statement from the Commonwealth, is that you don't have any physical evidence tying the defendant to the crime. Is that correct? You have his statement that he knew the body was covered with leaves, although it was in a forest, so that's not, you know, that's what it is. And he knew where the body was. And obviously that has some self-evident incrimination to it. But there's no DNA, and in fact, the DNA you have is not his, right?
Correct.
So him saying, "I killed the girl," seems, in terms of a prejudice analysis, seems quite significant.
I'm not sure what prejudice, and I'm not trying to be obtuse or ask questions, because I'm not sure.
Well, I may be mixing you up with the bail appeal, but in any event,
Correct.
It was less than clear to me here what the strength of I thought at one point you argued here that there was a strength to the Commonwealth's case.
Your Honor, that's as it relates to the bail argument, which would be the next argument. As to the statement argument, that particular statement was not suppressed. It's not part of the analysis as it relates to the break in the stream of events or the cat out of the bag. However,
So let's go to the next thing where I am a little concerned about the Commonwealth's position, because you've said to us that you have a burden to overcome the presumption that statements should be excluded, but that your burden is only by a preponderance of the evidence. The defendant then cites several cases to us saying, no, it's beyond a reasonable doubt. And we don't have a reply brief from the Commonwealth telling us they're right or they're wrong. So again, you're leaving us, you know, which obviously we're very capable of reading the law, but it would be, let's just say, more helpful if we knew the Commonwealth's position. Are you still saying it's preponderance, or are you saying, oops, it was actually beyond a reasonable doubt?
And Your Honor, as to the reply brief, it's not required. I believe that I could answer that question in oral argument. Yes, it is still preponderance. If you look, and I believe if you look at the cases my sister cites, specifically when they changed it to the harmless beyond a reasonable doubt standard, that is Commonwealth v. Tavares, which is 385 Mass 140. It's a 1982 case. I want to point specifically to page 152 and the language that the SJC uses, which, and I'll quote, "Before any statement made by a defendant to law law enforcement officers or their agents may be admissible at trial, the Commonwealth must prove voluntariness beyond a reasonable doubt. Specifically, it does not say any statement, and it says that it has to be a statement made to law enforcement officers. The statement that we're talking about here is a statement that was made to a private citizen, not a law enforcement officer or its agent. I believe because of that, if you look at the Monkey case, that involves statements that are made to private citizens, not law enforcement officers, so the preponderance standard would apply.
Let me stop you there. I have a question along the lines of Justice Henry's question, and that is, do we have a video or transcript of the police's interview with Pastor Troutman?
We do. It was submitted as part of the Rule 15 application.
Okay, do we have it?
As part of this record.
This record? I didn't see it.
I don't believe so. It was before the judge. It was before Judge Davis. He specifically, and this is on page 3, mentions reading the transcript of Pastor Troutman's statement.
Do you make the argument, I don't think you do, but I'm not sure, do you make the argument that any of Judge Davis's findings of fact are clear error?
No.
Okay, then let me so-called taint.
Correct.
My understanding is that the analysis as to both, they're not really prongs, both different methods of overcoming the taint are essentially questions of fact. Is that correct?
I don't believe so. I don't believe so because I think here, if you look at it, the Commonwealth's argument is that Judge Davis had an error of law in the way that he applied the analysis.
Okay, so it's, I just want to make sure I have this clear, because there's a number of cases, Prater, Monkey, Torres, Thomas, which all suggest that the focus and ultimate goal of undertaking either or both lines of analysis is a determination of voluntariness of the later confession. That is a question of fact. All of the cases say that. So my understanding is that these are questions of fact, and if you're not challenging them, we must accept those findings by Judge Davis. But your argument is his ultimate determination is an error of law.
Correct, because if you look at the fact, because I think the determination as to voluntariness, that isn't a fact, right? Whether something was voluntary or involuntary. I think if you look at the correct application of fact, you necessarily have to apply those facts to a correct standard of law. As it relates to the break in the stream of events, Judge Davis's error was that he looked at the internal circumstances that the defendant was feeling and not the external circumstances. And if you look at a case like Prater, that's a good example, or Monkey, or any of the cases that have followed since, it looks to see whether the circumstances which created the coercion still exist or whether they've been taken away. And here, if you look back to Judge Moriarty's finding, which Judge Davis did, Judge Moriarty finds that the defendant's will was overborne because of the length of the interview, because he was tired, because he wanted to go home, because he needed medicine. And if you look at the facts as they exist, which...
And the coercive police techniques.
The coercive police techniques, correct. If you look at the facts that Judge Davis found, and just look at the sort of, to answer your question, throw out the analysis section, just look at those facts and apply those facts and look at it in an external lens. Look at those facts. You see, when you look at them externally, all those factors have been taken away.
So to be clear, you are not challenging Judge Davis's findings of fact?
No. No, it's the application of fact, because I think the ultimate determination of voluntariness has to be looked through the correct legal lens, and those facts have to be applied that way. And he finds the facts there, right? He finds he's gone home. He finds it's been a few hours, and if you look at the transcript, the interview ends at 4:51. There's, you know...
It's arguably an hour. It's arguably more than a couple of hours.
Correct.
It's not exactly
It's not
clear.
exact. Interview ends at 4:51. Pastor Troutman says that he testifies, and there's a hearing in which he testifies before Judge Davis. He testifies that the phone call is made between 6:30 and 7, so it at least is between 5:51 to 6:30. Let's bring it that. If you want to even talk about police...
5:51 or 4:51?
4:51. 4:51.
What was that?
4:51?
4:51, so an hour and a half to close to 2 hours?
Correct. Correct.
So now that we've gone for 13 and a half minutes on background, let's cut to the chase.
Yes.
This is a difficult case, at least for me, perhaps not my colleagues, in this respect. On the one hand, it seems that Judge Davis made very clear and comprehensive findings that seem to fit the cat out of the bag theory. On the other hand, I don't see any precedent for a situation like this where there is a break, a person has called a civilian who is not related or has anything to do with police or the police coercion, and the cat out of the bag theory has been applied in a situation like that. So what do we do with that scenario?
Yeah, and I would say it supports that this factual scenario doesn't fall into the analysis, that it doesn't apply. I think it's interesting, and the first time the cat out of the bag theory is sort of announced is in the Monkey case, and I think the language, it says exclusion of the statement would be inadmissible if in giving it the defendant was motivated by the belief that, after a prior coerced statement, his effort to withhold further information would be futile, and he had nothing to lose by repetition or amplification of the earlier statement. Monkey has to do with private citizens, so sort of there is no precedent that neatly fits with our case, right? So if you're talking about a statement that's given...
So I'm going to interrupt you. Your time is up, but we spent a lot of time sort of trying to get the lay of the land in this case, and I have more questions, so I'm going to afford you some more time. I assume my colleagues have more questions, and Attorney Kiley, I promise you that you will get additional time as well. This is an interesting case, so go ahead.
I would say that Monkey has to do with private citizens, right? But it's different insofar as there's a group of vigilantes in that case that take the defendant. The subsequent statements that are made to them, it's the same group, right? They find that there's a break, but it's the same group trying to exact more information, specifically the location of the body. So in a way, though it has to do with the private citizens, it's not like this case in that it's not the same body that caused the coercion that's asking the questions. If you look at cases that sort of further down the line that interpret this, almost all of them have to do with subsequent police questioning, and the case law reflects that. If you look at a case like Prater, for example, they re-articulate the standard. They say, in other words, whether the defendant felt he had nothing more to lose by continuing to speak to the police. So there's a recognition that it's continuing to speak to the police. There are sort of three...
But is that's my concern, though, is that just because that's the fact of the case? Just like circling back to your argument about what the standard the Commonwealth has to meet in, if that case involves statements to the police, then I would see the court might say statements to the police, even though I hadn't considered this factual scenario where you have statements to somebody else. Like,
Certainly.
what's the difference?
Certainly. I think the answer to that question is to look at the other cases that sort of continue down that line. There are sort of three which I think are informative and may help flesh out what the correct sort of analysis and standard would be. I think the most applicable to sort of ask a question sort of directly as to what Justice Neyman is saying is Commonwealth v. Thomas, which is cited in the Commonwealth's brief, but can be found at 469 Mass 531. It's a 2014 SJC case. In that case, it involves questioning by the police in a Miranda violation, but specifically, and this is on page 551 to 552, they analyze it under the break in stream of events and under cat out of the bag. But then they say there are independent other grounds by which you would find that statements are admissible, and the statements that they're speaking of are statements that a defendant makes unprompted to a booking officer after the tainted confession. These statements the SJC held are admissible because they were made spontaneously in a conversation initiated by the defendant to an officer who was not involved in prior questioning in a different part of the police station, thus was not a product of the prior questioning. I think that is what's directly applicable here. I think you can apply that law because it's a third party that was not involved in the questioning, is removed from the coercive sort of elements that made the first statement coercive. It's in a different location. It's in spontaneous, it's initiated by the defendant. There really is nothing to say.
Well, it's not spontaneous. The pastor does ask him why he thinks he's going to be arrested.
Correct. It's not spontaneous. I don't think it falls, if you look under the cat in the bag language, though, it sort of contemplates further questioning by the police, not calling a third party and them asking, what are you talking about? Why would you be arrested? I don't believe that's the same type of questioning that's contemplated in most of these in most of these cases involving the questioning. I also think it's important too, and this is going right back to that monkey standard, which talks about that the defendant has nothing to lose in repetition or amplification of the earlier statement. I think it's important that the statement he makes to Pastor Trout is different than the statement he makes in that suppressed version that he says to the police, and it's different in critical ways. To the police, he says, "I dropped the rock." He specifically says it was an accident. I would say that that is an exculpatory version of events. Now, I won't go so far as to say that doesn't let the cat out of the bag, because he still puts himself at the scene of the location manipulating the murder weapon, but he gives himself a defense. It was an accident.
Here he said to the pastor, "I dropped the rock on her head," and then corrected himself later and said, "I threw the rock."
I threw the rock on her head, which is intentional conduct. None of that was mentioned to the police in the statement that was suppressed or prior to that.
Why does that matter in the cat out of the bag analysis?
I think that matters to the cat out of the bag analysis because it's not simple repetition. It's important when you look at it, and if you look at a case like Meehan or other cases in which it's found to apply, that the defendant has such futility that he's just repeating the things that he said before. In this instance,
He speaks to the notion of it's not just repetition.
there typically are cases in which they say the cat was either. That's a good question.
Well, I earned my dollar today, so that's good.
Yeah, you did. You did. I can, typically it's the opposite, right? The cat's out of the bag already. They say it's fine. If you look at a case like Meehan, they say in Meehan, it's a short time later. It's in the same place. There's no opportunity to consult, and he largely repeats what he said before. Again, and this falls into, there's no precedent that neatly falls into it. This is different, and it's different in that it's more inculpatory, and I think that's important because if you look, and this is not necessarily dispositive, but typically if you're looking at whether a defendant's will was overborne, the fact that he gives an exculpatory version to the police and withholds certain information shows that his will was not overborne to an extent in which it would be involuntary. I support that those coercive circumstances, he was able to withhold that, right? He was able to withhold this more inculpatory version, and I think it's important that once the allegedly coercive elements were taken away, once he's talking to a private third party who's not the police, he gives a different version in which he has intentionality, which he's added to his conduct. I think that's important.
So how do we factor in the finding that he had cognitive impairment? Because I don't see you grapple with that in your brief.
That has to do with the suppression as to the last 18 minutes. I don't think that necessarily has anything to do with the break in the stream of the break in the stream of the events or the cat in the bag analysis.
Let me,
Do you?
oh, I'm sorry.
No, go ahead, Justice Ditkoff.
I was going to make a final thought about the record, so if you're still in on the narrative.
Sure, I'm trying to understand. We have statements to the police that seem to be what most of our cases have to do with. And then we have statements to family, and then we have statements to pastor. And I guess I'm wondering where are you putting pastor as more remote than family, and what's the basis for that? Because many people might feel their spiritual advisor falls somewhere closer to the police, and that, the pastor asks a question and lying to a pastor is just not a great practice. So where do you fit that?
So I guess I'm not, I guess I don't, to sort of talk about the spectrum of cases, I'm not sure lying to family, I'm not sure what family cases you're referring to. I think most
So
of
you were distinguishing, it seemed like you were saying that there would be, that a pastor would be more remote somehow than family. I'm trying to understand the basis for that.
I don't, if I did make that argument, I don't think that was an argument that I was intending to make. I think that it's a non-police conversation, that it's a conversation made by a third party unrelated to the questioning that happened before that was found to be tainted, insulates it from the tainted coercive qualities that existed.
Meehan was a family case.
Meehan was a family case. However, the statement is he's in the cell and he just calls it out. And they say he didn't have the opportunity to speak to his mom prior to making that statement. I think it's important in that case, they specifically find it's a short time later, it's still in the same location, and he's in a holding cell at the point that he makes that call out. I think the facts here are very greatly from that in that respect.
let me see. Justice Henry, any further questions?
Is it correct that the defendant had never implicated himself in this murder for the prior 30 years before this interrogation?
Yes?
Justice Ditkoff, anything further?
Yeah, let me make a suggestion. This is a first-degree murder case, and we at least need to have the opportunity to have all the information. And I know your friend objects to some of that, but I think you're going to need to get together the video, the actual transcripts that were given to the judges, the exhibits at the second suppression hearing, and file a motion for leave to file those with us, and then your friend can tell us exactly what they're okay with and what they're not, and we'll have to figure it out. But I think we're at least going to need to have the opportunity to have those things.
Correct. I think
It would be helpful, too, if you could actually do that in comparison of the transcript you gave us and the one that the judges gave, or at least tell us what the differences are.
what the differences are. I'd be happy to do that. I think it's important, too, in terms of what the record is and isn't, that Judge Davis was very clear that he was taking judicial notice and considering everything that Judge Moriarty considered. So I think it would be fair to send up everything that Judge Moriarty considered. And if you look at Judge Moriarty's opinion, he both watched the videos and read the transcript. So
I'm not trying to limit what you can move.
No,
to have us
I'm
look
just-
at. Whatever you think, you should put it all
Correct.
together and move to have us see it, and then we'll
Okay.
get a response from your friend, and then we'll figure out.
Okay.
But I think we at least want to have the opportunity.
to see it, yes. And I agree with that. I think to give you a roadmap as to what I would
To be
include.
clear, Justice Ditkoff's suggestion, as always, is an excellent one. To be clear, this is going to be filed, though, as he said, in the form of a motion. We are not guaranteeing we're going to accept it.
Absolutely.
The panel will take it under advisement.
Absolutely, absolutely. I thank you for the additional time, and I rest on my brief otherwise. Thank you.
Thank you very much. Attorney Kylie, your 15 minutes starts now, and as stated, you'll have more time as well if needed.
Thank you. Good morning, and may it please the court, Rebecca Kiley on behalf of Michael Hand. With me at council table is Craig Tavares, who represents Mr. Hand in the Superior Court, and will be arguing
Morning.
the next appeal that you'll hear. The only question properly before this court is whether Judge Davis correctly determined that the statements Mr. Hand made to his pastor were excludable as the product of his involuntary statement to police. So I'd like to focus on that unless the court has questions about the...
The only question
Well,
I
I'd like
have is, go ahead, Justice Henry, please.
I'd like to nail down this standard issue because obviously the difference between beyond a reasonable doubt and preponderance is significant. And, you know, this seems to be,
Yes.
we don't have, I mean, as we've indicated, we do quite a bit of work before argument, and the Commonwealth sort of left us hanging and left us, you know, I would have preferred to hear from them what their position was before argument. So now we've gotten their response, which we've taken our notes about, and we can rewatch this hearing. But I guess I'd like, and now you've gotten their response, and we're stuck with whatever your on-the-fly response is, and this is a really significant issue.
Yes, and I would be happy to start there. I think that the standard is one of 4 legal contexts that make this appeal a particularly uphill battle for the Commonwealth, and that is because the standard is clearly, for voluntariness, the standard is beyond a reasonable doubt. The court said that in Tavares, and Ms. Campbell is correct that they said that as to statements to police, but in Commonwealth versus Allen, which is 395, Mass 456, and is cited on page 23 of my brief, the SJC explicitly held that statements made to civilians, to non-law enforcement, also must be voluntary beyond a reasonable doubt. There's no question.
Where did Judge Davis find this statement was involuntary? He just found it was tainted.
Well, he found that it was the product of the involuntary statement to police.
Right, but something being tainted by involuntariness, is that the same thing as it being itself involuntary?
I think in this circumstance...
That's what the federal courts did. They just said it's involuntary or not and stopped there. And that's what we've rejected.
Right. Well, and I think this leads me to a couple of the other legal contexts that I wanted to mention that are important here. One is that there is a presumption of a taint following a tainted statement, and here the taint arises from a statement that isn't just, you know, it's not a freely given statement that happens to not be Mirandized. It is an involuntary, coerced statement. And so the question always in looking at the second statement, Monkey makes this clear, is this second statement voluntary? And here it is not voluntary for two reasons, but both because there's no break in the stream of events sufficient to insulate it from the circumstances with a coercive statement, but also because the cat was out of the bag. And I want to get to that as soon as I mention just the fourth legal context here that I think makes this difficult for the Commonwealth, and Justice Neyman, you alluded to this. But Judge Davis's factual findings and Judge Moriarty's factual findings, to the extent that Judge Davis relied on them, are entitled to deference from this court. And here I just want to briefly say, unmentioned by the Commonwealth in all of this is that there was an evidentiary hearing before Judge Moriarty on the suppression hearing at which 2 witnesses testified. So this is not a circumstance where anyone can review, if the court were to review his suppression order, and I submit that you cannot, but if you were to do that, you don't have the transcript of the evidentiary hearing.
I gather you do, though.
I believe that Mr. Tavares does.
I meant you in the collective sense. The defense does, at least.
Sure.
So going
But in any
back going back to what you say, though, in terms of no break in the stream.
Yes.
Your opposing counsel argues, but that there were some significant changes in the external circumstances. He wasn't with the police anymore. He was at his home. He wasn't talking to the police anymore. So why is she wrong about that?
Well, and here, again, I think it's really important that this is a case where the first statement is involuntary, because what the Supreme Court has said about the break in the stream question is, it's not just, is there a break? Is there a change in location or circumstance? The question is there a break that is sufficient to insulate the subsequent statement from all of the coercive effects that produced the first statement, right? And so the Supreme Court, for example, in Cluis v. Texas, which is 386 U.S. 707, and there were very coercive circumstances. But the Supreme Court said 9 days wasn't enough to break the stream. So here, the mere fact that he goes home is not enough, because the coercive circumstances, which Judge Davis found as a factual matter, are the cognitive limitations that Judge Moriarty found based on evidence before him and were credited by Judge Davis, which obviously are still in play, and his emotional disturbance as a result of the experience that he's just had after a very lengthy police interrogation where Judge Moriarty found his will was overborne, he was exhausted, he was wrung out by this experience, and Pastor Troutman testified and Judge Davis credited, he was still disturbed and distressed and upset and erratic about what had just happened. And I understand the attempt that the Commonwealth is making to say that those are not external circumstances, but this court has recognized precisely those kinds of circumstances as the external circumstances that are relevant to the break in the stream analysis.
So what's your...
Go ahead, please.
I just want to know your best Massachusetts case on this, because I wasn't clear from that, from your brief.
I think probably overall the best case for us is Meehan, and I do want to just note that in Meehan, although it is true that he's still in the police station, the time period that lapses is longer than the time period here. There's more than 3 hours between the involuntary statement and the statement to his mother in Meehan. But on just the specific question of can you consider his cognitive limitations and his continued emotional disturbance when you're looking at whether there's a break in the stream, I think Commonwealth versus Paliki makes it clear that you can. And in that case, the defendant loses because what this court said is that her intoxication and her emotional disturbance were the coercive circumstances that made her first statement involuntary. And then the court finds that by the time she makes the second statement, those things have receded. But here Judge Davis found that they hadn't receded. He's still emotionally disturbed. And I think that is a factual finding that you can't revisit.
Let me ask you this hypothetical. Same set of facts, assume defendant's statements to the police merely put him at the scene and acknowledges the rock. That's it. After the interview ends, assume there's an hour and a half that goes by, defendant calls a co-conspirator who was there with him, and committed the crime with him, and says, The police know that we killed the woman, and they know I had the rock. Any difference in the outcome here?
Well, I think it would depend on what the evidence was about his state when he made that phone call.
Let's assume it's the same state that the judge found here.
Then, no, I don't think so. And I don't know if what the court is getting at is Ms. Campbell's argument that the cat is not quite out of the bag because it's not.
What I'm getting at is that, and I can't speak for my colleagues, thus far in my research, I have not been able to find any cases like this involving a violation of Miranda, followed by the passage of time, where a defendant calls a civilian, the defendant initiates the contact, he speaks to a person with whom he has a personal relationship, he speaks to a person with whom he has a special relationship, which with that there's an indicia of trust and reliability to the statements, which is different than most of the cat out of the bag cases, and that's what we're concerned about here. That strikes me as possibly a different scenario. I'm not saying that it requires a different result, mind you. I'm just saying I can't find any cases like this one. So where can you direct me?
Right, I agree that that's true, and I just want to address two things that were in the question that you just posed. The first is, this is not a Miranda violation. I know I keep saying this, but this is a...
You know what, and I shouldn't have said that,
But it
where
does-
it was an involuntary
Yes.
confession.
And
Yes.
again, I think that really matters, and
Yes, it does.
there are not a lot of voluntariness cases, and in particular, there are not a lot of cases where the judge found involuntariness below, and you were reviewing to decide whether that was error. But I've lost my train of
I think
thought on the second point.
maybe we're on the wrong path here, but my colleague was talking about this sort of spectrum of people you're talking to, and there's law enforcement, and we see all these cases where it's law enforcement and law enforcement, or the captors, vigilantes, but then we have sort of at the far extreme, you get involuntary statement, and then you call up your buddies and tell them to go suppress, go hide the evidence, and we certainly can't get there. And so we're kind of trying to figure out where a pastor like Troutman sort of falls on this, this sort of spectrum of people you're talking to.
Right. I mean, I think the same legal standards apply. The question is, beyond a reasonable doubt, is there a break in the stream of events, and is the cat out of the bag? And if I could return to the other point that I wanted to make, Judge Neyman, about your question, you mentioned that the statement to Pastor Troutman here seems particularly reliable. I would disagree.
No, I didn't say it has.
Oh, I'm sorry.
I said because he is initiating a call and speaking to someone with whom he has a specialized relationship,
Okay.
I'll call it, there may be indicia of reliability.
So there may be indicia of reliability. What I would say is, I don't think that matters, because even a reliable involuntary statement is still never admissible under the Fifth Amendment to the United States Constitution. This is an automatic self-executing right that he has to never have this used against him, and it is distinguishable from statements obtained after a Miranda violation in that way also, right? A statement that is involuntary can't be used even to impeach.
But in determining voluntariness, context matters. How much time has passed? To whom are you speaking?
Sure.
What is the context in which you are speaking? What is your tone? What is your state of mind? All of those things matter. So I think to whom they're speaking, and whether or not it's the product of a coercive discussion, or whether it's an entirely new discussion after a break, those are all things we take into account in making that analysis.
Right, and this is obviously a different conversation, but again, Judge Davis found that he was still in the throes of this emotional disturbance that was occasioned by the coercive police interrogation that he had just been subjected to. I want to just respond to
The Commonwealth, though, says, well, yeah, but he was, even if his will was overborne with the police, he held stuff back, and that the statements to the pastor were much more incriminating, so it wasn't simple repetition. And what do you say to that?
Thank you, that's right where I wanted to go. Two things. One is, I don't think that the statements are particularly different. It is true that Pastor Troutman doesn't testify that he explicitly says this was an accident, but the gestalt of the story, which does involve this weird claim that he was trying to protect her from this other man known to have killed another girl is the same. And it's, the difference is whether he says that he accidentally dropped the rock or whether he threw or knocked the rock onto her. But more importantly, the case law makes it clear that this can't be dispositive in favor of the Commonwealth. And I cite on footnote 18 of my brief, Commonwealth versus Smith, where initially the defendant's statement just puts himself in the company of the co-defendant at the time that this murder happened. And then subsequently, the second statement, he admits both that he knew about the murders and that he helped the co-defendant cover them up. So it's a far more inculpatory statement. I think the difference there is much bigger than here. The same is true also with Commonwealth versus Osachuk, which is another case that I cite in my brief, where the initial admission is just, I was doing drugs with this woman when she overdosed, and then the subsequent admission is, okay, after she overdosed, I injected her with cocaine to try to save her. And the court says, that is, the court recognizes that's far more inculpatory, but says it doesn't matter. The cat was out of the bag the first time. And here, that's obviously true. The cat is out of the bag.
What do we do about the fact that Judge Davis finds that at the time defendant spoke with Pastor Troutman, he remained disturbed, distressed, desperate, and frustrated by what he understood were the implications of his earlier statements to the police, not by the coercive things, but this sounds like he's jumped right to cat in the bag there. He's disturbed not by all the stuff that was done to him, but by what he had said.
Well, first, I think it may not be fair to parse it quite so finely and say that I understand that he is recognizing the effects of having made the statement, but I think, I don't know that he intended that to say, and he's not upset at all about what the police just did to him. But I guess, I would point the court to Justice Harlan's concurrence in Darwin versus Connecticut, which has become really a foundational case on the cat out of the bag context. And there, what Justice Harlan said essentially is that the question of the break in the stream of events is about the continued effect of the course of interrogation, and the question of cat out of the bag is about the effect of having made the admission. And what he says is...
Oh, your time is expired, but
yes.
We're going to give you more time.
Thank you, I appreciate it. And what he says is that in the context of an involuntary statement, which is what Darwin involved, the subsequent statement has to pass both of those tests in order to be admissible, because otherwise it's not voluntary, right? A statement that is the product of an involuntary confession is not voluntary, and a statement that is the product of a coercive interrogation is not voluntary.
Which case are you talking about again?
This is the Harlan concurrence in Darwin versus Connecticut. And I think what the SJC has said repeatedly is whether they have to prove one or both depends on the circumstances of the case. So sometimes you see Miranda cases where there's no break in the stream of events, but the cat's not out of the bag, and the court says no problem. I think that's very different than the circumstance here, where, if this statement is the product of a coercive interrogation, it's involuntary and it violates due process to admit it. If it is the product of a coerced statement, it is involuntary and it's not consonant with due process to admit it.
So what's your best Massachusetts case for the notion that this is an and test, not an or test?
I think,
because if I understood what you just said, that you've indicated the SJC's gone back and forth on this.
well, I think what the SJC has said, and I believe I cited a case in my brief, and I'm sorry that I don't have it at my fingertips, but is that it depends on the particular facts of the case. And my argument is that on the facts here, you've got to find both. I mean, the Commonwealth has to prove both. And, I don't think they can prove either, so I think the result is the same for Mr. Hand either way.
What is your best case on the notion that it really doesn't matter whether the defendant's subsequent statement is to a civilian or to law enforcement or someone connected to the case?
Well, I think both Commonwealth versus Allen, which I already mentioned, which establishes that the standard for a statement to a civilian is proof beyond a reasonable doubt, or Commonwealth versus Meehan, where the statements are made to the defendant's mother and not to law enforcement, and nonetheless, the statement is suppressed.
Let me Let me throw a few cards on the table. I'm really struggling with a case that isn't discussed in your brief, which is the Jones case. I mean, most of the cases we have don't get the Commonwealth that far because they're all affirming whatever happened below. But Jones is a pretty recent case from our court reversing a suppression and reversing it on the grounds that there was a substantial break in the stream of events between the defendant's encounters with officers, and that was an hour, and it was officers and then officers again. And so I'm having a hard time understanding how I can have that case and this result.
Well, I think because it's always a fact-specific inquiry. There's no bright line rule that says, 30 minutes is too short, but an hour is enough. And again, as I said, the United States Supreme Court has, in one particular factual circumstance, said 9 days is not enough to break the stream of what happened. Because, again, the question is always, is it sufficient to insulate the second statement from everything that came before it? And so, I would submit that the difference between this case and Jones is that the court presumably just concluded in Jones that, this initial unlawful pat frisk, while I certainly don't want to diminish the significance that might have had on the defendant, presumably did not have the effect that Judge Davis and Judge Moriarty found, that this, 10 plus hours of interrogation combined with Mr. Hand's diminished cognitive abilities and his emotional disturbance, right, that left him in a different place. And so more was required to break the stream there. This is a case in which the combined conclusions of two thoughtful judges are that the police coerced an involuntary confession from a cognitively disabled man who then, within an hour and a half, repeated the statement to his pastor while still in a state of emotional disturbance. And for the court to overturn that, you'd have to conclude that Judge Davis should have found that with unmistakable clarity that the record established the voluntariness of these statements. And I just don't think that this record would permit that kind of conclusion.
Where's the language unmistakable clarity?
In Commonwealth versus Tavares, which sets
Tavares.
forth the burden of proof.
Justice Ditkoff, Justice Henry, any further questions?
I have a lot of notes on this case. Let me just double check. No, that covers it. Thank you.
Thank you.
Seeing no further questions, the case is submitted. Thank you both very much for excellent arguments.
You better if they stay where they are.
And the case is submitted. Calling our next case, you need not go anywhere. Commonwealth versus Hand, 23P301.
Going.
Will not be affording additional time on this case. So we will hear first from counsel for the defendant appellant.
Thank you, Your Honor. Good morning. May it please the court, Craig Tavares, on behalf of the petitioner, Michael Hand. In this case, the lower court judge made errors of law and abused his discretion in denying the petitioner's renewed motion for bail in a very brief docket entry that effectively deferred to a prior judge's bail decision from almost 2 years prior. As suggested in the briefs, it's the petitioner's position that the errors are interrelated. First, there is the factual error that there's not a substantial change in circumstance for bail purposes, and then once Judge Layton finds that, then you have the deference to, it doesn't change Judge Squizley's analysis. And the suggestion here is that under Vasquez, when the SJC has indicated that in the first bail argument, but also in a motion to reconsider, there are certain elements that need to be addressed, certain factors that need to be considered to be consistent with due process, that is insufficient here, as well as I'll talk about the very short sort of statement of findings and reasoning in this case, which again is really not substantive as far as that docket entry. And why is this important?
So I think the Commonwealth is going to get up and argue in a minute that the key thing is that he admitted that he killed the girl and that did not change. And that's a very large admission.
Judge, a couple things
Your
on that.
response.
Sorry, Justice Henry, a couple of things on that point. The first is, you don't have the video, I didn't know that, but the irony of this case is neither of the police officers in the room asked Mr. Hand about the supposed "I killed that girl" statement. They don't arrest him, they drive him home, and they submit a probable cause affidavit, which was admitted as an exhibit before Justice Davis in the fruit proceedings. And in that probable cause affidavit, they don't have "I killed that girl." They actually rely upon the now suppressed evidence when, at the end of the interrogation, Mr. Hand, as Justice Moriarty found, sort of takes the minimization and takes the, it was an accident when he was looking for her to sort of be this good Samaritan. So that is a dispute in this case about whether that statement was made, and I would suggest to the court, if the Commonwealth had an unequivocal confession, "I killed that girl," begs the question about why there was an interlocutory appeal before the third trial date to address I believe Justice Pastor Troutman testified, it was like 15 or 20 pages. It's a very short transcript. It's a very short witness. So I think the Commonwealth sort of overplays its hand, Your Honor, as far as...
If the Commonwealth's case is so weak, why did you try to exclude it, causing the delay?
Well, I'm glad you brought that up, Justice Ditkoff. And I addressed this in the reply brief. There was a suggestion by the Commonwealth that the defense sort of sat on its hands and right before the June trial date filed the fruit motion, and that kind of set things into motion. And not to make this about myself, there is in the record that the first trial date was continued by agreement. My mom had just passed away. I was out for a bit. But if you look at, I believe it is where is it? I cite to it in the reply brief, but essentially in the record appendix, the Commonwealth opposition below is included, and the Commonwealth specifically says in its opposition in the trial court that it did not know it was going to offer Pastor Troutman until it filed the motion in limine. That motion in limine was filed in December of 2021, a few weeks before the trial date, when unfortunately I was dealing with that personal circumstance. So the Commonwealth's argument on appeal is a little bit different than it was below, which was below there was no suggestion that it was the defense's delay. In fact, in her opposition, which again is in the record appendix and cited too in my reply brief, she sort of says that it's a complicated procedural history, no side is sort of at fault, that there's been all these issues and things of that nature, but there's no suggestion below that the defense sort of, sat on this. She concedes that she raised the Pastor Troutman issue, and that's when it gave notice to the defense and the court that this was going to be an issue. So I reject the premise that the defense sort of is at fault and that the defense sat on its proverbial hands.
I wouldn't have assumed they were going to bring in a pastor from North Carolina and try to get through the penitent privilege either, but you did have the information about the pastor statements well before, right?
I think that's fair to say. There's boxes of discovery in this case. I think I would have to admit to the court that I was aware and familiar that they did speak to the pastor at some point, but in the Commonwealth's own words below, it was December of 21, right before the first trial date, when that got brought up. And if I could just briefly talk about the trial continuances, there's a suggestion by the Commonwealth that despite the protestations of counsel that the defense did not object below. I again cite in the reply brief to the record appendix where Ms. Sprague for the Commonwealth, in discussing the procedural history, does not make that claim. And I would suggest to this panel that the reasonable inference is she was there and she saw me objecting. I can tell the court I did not expect this to be an issue. I don't just check dockets all the time. I did get transcripts of the 3 motions to continue the trial dates. I can submit those to the court if it pleases the court. But again,
I think we're getting mired in a lot of issues here when isn't the issue before us whether or not the single justice abused his discretion here?
I would suggest to the court under Vasquez that the single justice is not entitled to any deference because, like the single justice in Vasquez, the single justice didn't exercise any discretion. The judge basically found that in light of the fact that Judge Layton waited until the next day that it was briefed, that he must have considered all these issues. And Justice Meade's decision, consistent, I think, with the single justice.
I'm sorry to interrupt. I just want to make sure we're on the same page. Is our standard of review not abuse of discretion here?
It is.
It is abuse of discretion, or it is
I think
not?
it's abuse of discretion in the trial court, though. I think, and I have the blurb right here from Vasquez on this. Whether the bail decision's decision to deny the defendant's bail request involved an abuse of discretion or an error of law. And I believe under Vasquez, it's important to look at it from the lens of Judge Layton, because in this instance, Justice Meade, I would suggest, similar to Vasquez, deferred to the lower court. And I can talk about the errors of law and abuse of discretion in a moment.
In that regard, I didn't see any evidence that you told the Superior Court judge about the defendant's physical limitations. I can see that in the single justice papers, but I didn't see that in any of the papers that have been filed in the Superior Court. Is there some place you did that?
I believe in the renewed motion, there was references to the defendant's advanced age, 66 at the time, that he comes to court in a wheelchair and or a walker, and that there are medical issues. And that on the day of the actual hearing, Mr. Hand was not present because he had been admitted to the hospital, and thus his presence was excused. His medical situation has deteriorated significantly since Judge Squires-Lee touched the case. In fact, he was in the hospital the other day. So there are some issues that may have to get addressed in the trial court. But I can tell you, Justice Ditkoff, that I believe in the record appendix, I don't have...
It does have your renewed motion for bail, but I don't see anything about the physical circumstances of the defendant there.
Yeah, my recollection was it was not a substantive discussion in light of the fact that, ironically, a lot of his hospitalizations sort of started that day, and there's been about 5 or 6 in between. But my recollection is, in that pleading, there are references, maybe without the degree of specificity that I should have had, but there are references to medical issues, and there's issues with mobility and the fact that he relies upon a wheelchair or a walker. If I can get to the errors of law, unless there's any questions. I think the significance here is the first part of the docket entry, Judge Layton says that there was no substantive change in the record. And I think there's 3 or 4 reasons that suggest that that's not accurate as a matter of law. The first is 2 years had passed, roughly 2 years, 23 months to be precise, between the argument before Judge Squires-Lee, her bail order, and then the argument before Judge Layton. In Commonwealth versus Vasquez, the SJC is pretty clear.
Sure, but the next sentence is, delay attributable to the pending interlocutory appeal does not change the analysis set forth in Judge Squires-Lee's decision, does not warrant the relief sought. So, despite what he said, he recognized there was more time.
In that little blurb, he doesn't, again, I think it's interesting that he states it doesn't change the analysis set forth in Judge Squires-Lee's decision. As I read Vasquez, I believe it's incumbent upon the judge, even on a motion to reconsider, to address a few issues that they raised. The length of the delay, the current equities of the case. Judge Layton doesn't reference anything in the case about the trial being stayed, and I think that's important. Judge Squires-Lee addressed it in pretrial proceedings after a motion to suppress. Judge Layton is hearing the bail argument after the 3rd trial date has been continued. And that sort of, I think, late posture, that trial issue and the prejudice that comes from having your 3rd trial date after 4.5, 5 years in custody stayed, I think it's a substantial change in circumstance that Judge Layton does not address. So it's not the same circumstance as Judge Squires-Lee. And also, not for nothing, but 15E, I suggest, Finney made it clear that may doesn't mean they take an interlocutory appeal, you're going to get released. But I think the language in 15E acknowledges that when the Commonwealth takes an interlocutory appeal, that delays the proceedings to the prejudice of the defendant, and the defendant may be warranted to bail reconsideration. So I would suggest it was an error for the court to indicate that there was not a substantial change in the record based on the additional years, based on the trial just being stayed, and based on the language in 15E. How it relates to abuse of discretion is that, again, notwithstanding the language of Vasquez, you don't have The current equities being discussed by Judge Layton, again, the medical situation, albeit maybe it was not as brief as well as it should have been, but certainly the additional time, the 4 years, the trial, and the 15E. But I think where the Commonwealth argues, well, that's okay under Finney, because in Finney, the SJC acknowledged that it wasn't a blank state and putting it all together. I would suggest to the panel that Finney's has some pretty significant distinctions, I think, from this case. The first is the record before the SJC. The SJC had both bail hearing transcripts. They talk about them with a great degree of detail, and they talk about at the end of the second bail hearing, when all these arguments are made.
Well, that's true, but you're the one who didn't give us any of the bail hearing transcripts. Why does that help the appellant?
Justice Henry Ditkoff, I can tell the court, when I filed the 211-3, I never thought that I would be here. I thought 211-3, single justice, it goes to the SJC, there's 2 weeks to submit that memo.
I understand why we don't have them, but I don't know why that helps the defense.
Well, I think it just distinguishes from Finney, where in Finney you have this significant record where the SJC could say, based on this record, yes, those statements at the second bail hearing would not be enough, but when you combine it all, it wasn't an abuse of discretion, it met with procedural due process.
For all we know, there were extensive statements at both bail hearings that explain what was going on.
Well, I can assure you there wasn't. Again, we don't have the transcripts, and I can try to submit that to the court. I don't know how quick that would be, but I think that's a distinction between Finney. And Finney also, the defendant did an interlocutory appeal. I think that affects the analysis. It was not just the Commonwealth. In Finney, he had some issue that he wanted to raise in the higher court as well. And also, I think what gets lost in this is that in Finney, the SJC and the lower court judges acknowledged that after the first trial, they got incriminating DNA evidence. We don't have incriminating evidence in this case. The Justice Henry's case question before, there's no physical evidence. In a case with significant trace evidence, hair fibers, sperm, touch DNA on the murder weapon, none of it connects to Mr. Hand. But more to the point, as Justice Moriarty acknowledged in the suppression order and R13 in the record appendix, there's clearly evidence of sexual assault. Her shirt is up in the front. She has no pants on. Her underwear is pulled down in the back. The sperm is in the rear crotch panel. As Justice Moriarty found, the litmus test in this case, a cold case, had been the sperm. And it's undisputed that Mr. Hand could not have contributed the sperm that was found in the 15-year-old victim's underwear. And there's no suggestion that it matches one of her boyfriends, an ex-boyfriend. It was the litmus test in the case for a reason. The issue is, after he made the statements, they probably thought, oh, it's going to match the DNA, and obviously that didn't work out that way.
Right, but what we do have is he seems to have known her location in the forest. He knew that she was covered with leaves, and maybe, I guess this is going to have some post-argument debate amongst the parties, but, maybe in a transcript it's inaudible, or maybe Judge Squiersley heard, or maybe we will hear him say, I killed the girl.
Justice Henry, what I can tell the court on that is that Justice Moriarty's decision in this regard, I think, is very significant, and that's in the record. Not only does he talk about the cognitive limitations, he talks about the disfavored police tactics, including formatting. There's a lot of formatting, but the specific example in the suppression order is that they showed a crime scene photo and asked if that's where he saw Mr. Meinholz, and when he was looking for the victim, and he denies it, and then they tell him, no, that's a photo from the crime scene, which he then adopts. So I think in evaluating the statements, you must consider the cognitive issues as well as the factors. I know I wasn't going to give additional time. Again, I would just...
Your time is up, but let me see if my colleagues have further questions.
I have just one final question. At one point in your brief, you say he was deprived of a meaningful bail hearing. But do you have any problem with the bail hearing other than the result of it?
Under Vasquez, we've got to get a statement of facts and reasons to be consistent with, they said it was like the bare minimum of due process. And I would suggest to your Honor that after almost 6 years of an individual who's presumed to be innocent being held pre-trial, I think procedural due process requires a lot more than what I would define a very under-inclusive decision. To reference a case that was cited in the JF case, which I have in my reply brief, it's putting aside the fact that we didn't get the decision for a couple months. I found out about it in January, unceremoniously 2 months sort of after the fact. But But yes,
That's your complaint, the decision.
It's the decision or the lack thereof. It's Judge Layton not considering the DNA and all these issues and the delay, but sort of saying that it doesn't change Judge Squires-Lee's analysis. I think that's problematic.
No, I understand. That's what I thought you were arguing. I just wanted to check, make sure I wasn't missing an argument you were making.
Sorry.
Justice Henry, any further questions?
All set, thank you.
Thank you very much.
Thank you, Attorney Tavares. Well argued. We will now hear from the Commonwealth.
Good morning again, Kaylin Campbell on behalf of the Commonwealth. Before I start, I meant to do this before. I'd like to acknowledge the victim's family who is present in the courtroom today. We ask you to uphold the denial of the defendant's 211-3. I think I'll start with the standard of review, which is whether Judge Mead abused his discretion in denying the defendant's 211-3 petition to review his bail. Judge Mead did not exercise independent determination as to the bail factors. He looked as to whether Judge Layton abused his discretion. And so if you look at cases, specifically the Vasquez case, it says the question is largely the same, whether the lower court judge abused his discretion. I think that standard is important, and I think there was a wide ranging with a lot of facts thrown out. I think what's important is what was before Judge Layton and what Judge Layton considered. If you look at the arguments that my brother makes, I think I'll start with that last argument that he made, that there is some...
But wait a minute, are we reviewing whether Judge Mead abused his discretion, or since you just said he didn't exercise independent discretion, are we looking at whether the lower court judge abused his discretion?
Under Vasquez, you look at whether Judge Mead abused his discretion. The specific language is that that the eye should be turned to the bail judge's determination, and the bail judge's decision must be afforded great deference and should not be overturned for an abuse of discretion merely because a reviewing court would have reached a different result. So the ultimate bottom question is whether Judge Layton abused his discretion, but it does have that Judge Mead denying the 211-3, which is the issue that's before the court.
By abuse of discretion, the Vasquez court specified it's LLV Commonwealth.
It's LLV Commonwealth.
Range of alternatives.
Reasonable range of alternatives, correct. And the case law has been specific, and this is in Vasquez itself, that this court can't ask whether it would have made a different determination than the bail judge or the single justice. The question is really that outside the range of reasonable alternatives. Now, I think because of that, it's important what was before Judge Layton and what Judge Layton considered, which was not the same information, as you pointed out, Judge Ditkoff, that was before Judge Mead as to the defendant's physical conditions. I also think it's important, and I cite the Finney case for this proposition. My brother argued in his brief, and he argued here today, that it was an abuse of discretion to Judge Layton to refer back to Judge Squires-Lee. I think Finney says that a judge can refer back to a previous bail judge's determination. When you look at Judge Squires-Lee's decision, it's a very thoughtful, lengthy decision, and she does look at all the evidence. I think what's important too is that she makes this decision post the motion to suppress, in which certain items had been suppressed, and she looks at the statement and heard all the same arguments as to the reasons why, the cognitive limitations of the defendant, and the reasons why his statement should not be considered. More important than that, the defendant does not claim in his brief that Judge Squires-Lee or Judge Layton make any factual errors, that any of their factual findings are in clear error, so this court should consider this under the lens that Judge Squires-Lee looked at.
Well, he certainly disagrees with her discerning that he said, "I killed her."
He does not, but I think Judge Squires-Lee talks about the fact that she watched the video and she hears it herself, and she makes that finding. He disputes that. I don't see in his brief any specific, in his first brief that he filed, any specific resuscitation to this court that was clear error. He doesn't provide the video to show that it was clear error. There's nothing by which this court could overturn that factual finding, and I think that's important. Now, this gets complicated, right, because there are two cases that are considering the same issue and both considering, but I think it's important to remember what's being reviewed and the specific arguments that are being made. Now, I do think that it's important that Judge Layton, and I don't think there's any deficiency in what he writes. He does in writing state the reasons why he is denying bail, and aside from the passage of time and the delay, there is no material change in the strength of the case or the factors by which Judge Squires-Lee made her reasoned decision to deny the defendant's bail. And so that is important too. I don't think there's any abuse of discretion in referring back to that. That being said, if you look at all of the traditional bail factors, the defendant can't get around the Vasquez language itself, which states that first-degree murder is looked at under a different lens, which is in light of the very overwhelming penalty that the defendant would face if he is convicted of this crime, which gives such a high incentive to flee. That, coupled with the strength of this case, and all of the arguments that my brother made as to why he believes the case were weak were made before Judge Squires-Lee, and she rejected them, and I think that's important, and Judge Layton could consider that, and he also rejected them. I don't think, given the reasoned decision, that this was outside the range of reasonable alternatives, which this court would have to find. I'm happy to answer any specific questions that the panel may have, but otherwise I'll rest on my brief.
Justice Ditkoff, Justice Henry?
So just to cover this, is there any physical evidence placing the defendant at the scene of the crime?
No.
And the DNA collected from the rock does not match the defendant?
No, there's no DNA evidence which places the defendant there, nor is that required to obtain a conviction under first-degree murder.
I understand it's not required, but we're looking at the strength of the case. And so the strength of the case seems to be that he made incriminating statements, correct?
Correct.
And do you know the status of what was presented to the judge below in terms of the defendant's physical impairments, which the record seems to be getting bigger, which it can't, of course?
Yes, it would be contained in the defendant's record appendix, which is not the same as was put before Judge Mead. I can't tell you specifically what the differences are, but it is contained in the motion that was before Judge Layton, contained in the defendant's record appendix. The defendant could try to expand the record. I would object to that. I think in the abuse of discretion standard, it should be focused on what was put before Judge Layton, and where Judge Mead didn't exercise any independent determination of his own, it should be restricted solely to what was put before Judge Layton.
And we're going to wrap it up there. Thank you both very much.
Thank
Well
you.
argued, and the case is submitted. It is now 11:12 a.m. This court will take a 10-minute recess and reconvene at 11:22.
Put all rise, please.
Thank you, Mr. Spatty. Calling our next case, docket 22P1078, STAG Industrial Holdings versus Black Swan Holdings. We will hear first from Attorney Otto, counsel for the appellant.
Thank you, Your Honor. Good morning. May it please the Court, I'm Douglas Otto. I represent Black Swan Holdings, the guarantor in a commercial lease case. The issue before you is what items are properly charged against the guarantor stemming from a tenant's default. The facts aren't very complicated and frankly aren't in dispute by virtue of the landlord's own testimony in the lower court. The timeline, however, is very important to this discussion because it speaks to the landlord's own conduct and bad faith in what is the guarantor's estimation that renders the liquidated damage clause disproportionate to actual damage in this case and not what the parties reasonably anticipated in the event of a default. So if I may, I'd like to run through that timeline. It begins on April 13, 2017. STAG Industrial purchased the subject property in this case in Gaffney, South Carolina from the Robert Allen Group. That purchase included the real property, the personal property, the intangible property of the Robert Allen Group. The personal property included machinery, equipment, personal property attached to or used in connection with the operation of the building.
I can tell you we are intimately familiar with the facts of this case. We have a very good idea about the timeline.
Okay.
It's your 15 minutes to use as you see fit, but if I were you, I'd cut to the legal arguments, and I actually have a question in that regard. Do you agree that the lease is governed by South Carolina law?
I do, Your Honor.
Okay. And so therefore, when we're evaluating the question that you pose, which is with respect to the liquidated damages clause, I want to go there first, we look to South Carolina law. Is that correct?
That's right, Your Honor.
And I think you stated your brief at page 25, there is no binding precedent in Massachusetts on the issue, and jurisdictions are split on whether optional liquidated damages provisions are enforceable. I didn't see you cite in your moving brief to any South Carolina law. Why is that?
There is a citation in South Carolina. Let me just find that for you. It's Lewis versus Premium Investment Corp. And it's consistent with Massachusetts law, which holds that the sum stipulated as liquidated damages cannot be plainly disproportionate.
I'm looking at your table of authorities. I don't see that. Was that cited maybe in your reply brief?
It is in the reply brief, Your Honor.
Okay.
Excuse me.
Are you familiar with a case called Richmond Enters versus Pamplin? It's a 1996 Fourth Circuit case applying South Carolina law.
I'm not, Your Honor.
Footnote 8 of that case seems to suggest that parties are able to, at least under South Carolina law, to, use a liquidated damages clause or preserve the option of the non-breaching party to seek actual damages at their option. So I'm not sure if that case answers the issue or not, but okay.
Your Honor, I would submit it does not. And I think the facts here suggest something different, which is why I was focused on the timeline. I will not rehash that, only to say that we get to a place where after seeking 3 extensions of time to move for an assessment of damage, we get to a place where we've got a South Carolina judgment for $579,000 rounded. We have a full 1 year of rent being charged against this tenant and therefore guarantor.
So I don't understand this form of analysis, because when we determine whether the damages are grossly disproportionate, we have to go back to when the lease was signed. So what, at the time of the lease, would make these liquidated damages grossly disproportionate?
Well, Your Honor is familiar with the first look approach, which the SJC has agreed with this appeals court on in the Cummings-Hines case. The first look approach...
Actually, they overruled us on that.
Well, overruled to the extent of applying relet type damages. I I mention it's because this guarantor, yes, could look at the liquidated damages clause, which closely aligned with the letter of credit that it was giving under the guarantee, or that it had the option of giving. So we have this amount, right? We have this amount somewhere in the neighborhood of $579 to $667 rounded in the hundreds of thousands of dollars. What I don't think any party would have anticipated is that STAG would have required the tenant to remove this racking. It's a false premise on which these extensions were based. And STAG's own witness at the hearing testified that they could have elected that liquidated damages clause a full year earlier. So what we have is a South Carolina judgment for unpaid rent. Then we have a notice of default and termination and right to possession. And we have a full year of rent. And then we have another full year of liquidated damages charged on top of these deferred maintenance, alteration type charges with no effort by this landlord to mitigate any type of damage. And so we quickly jump to a figure in that approximate $579 to $667,000 range to an excess of $3 million.
But there's nothing in the lease that says there's a cap on this liquidated damages, right?
There's nothing in the lease which says there is a cap.
And it does say that it's not just the rent, but it's these other expenses that the tenant has to pay.
So these other expenses are very much at the heart of this case. What are those other expenses that are properly charged to the tenant? And I would submit to you.
Well, I mean, I have to say usually liquidated damages means you get that one element of damages and you don't get the missed rent and the extra, it seemed like, year of rent plus the liquidated damages.
And I think that's a fair interpretation. This guarantor is not complaining about the South Carolina judgment or the idea that there's a liquidated damages provision. This guarantor is complaining about the fact that they took a full year based on a false premise in motions to extend before the lower court, saying that this tenant had delayed in vacating, and they had not.
Okay, now I'm confused. Are you challenging the liquidated damages or not?
The liquidated damages clause is an unenforceable penalty in our view. The reason it is because it is so disproportionate to what actual damages are. And so we think
or would have been anticipated at the time?
I think a fair reading of both the liquidated damages clause and the letter of credit provision in the guarantee suggests that the parties anticipated a reasonable amount of damages to be in that $667,000 range.
Before we get to the letter of credit, suppose that your client defaulted. Well, not your client, but you're the guarantor. You're the guarantor for the client, right? Suppose there was a default, and suppose that the landlord spent 5 years attempting to lease the premises and was just unable and tried other ways to mitigate and couldn't. Could actual damages have been the total rent for that 5-year period, assuming there were no statute of limitations issues?
Could have been had the landlord chosen the other remedy under the termination damage clause, but they did not. They chose the liquidated damages remedy. And so if we get to that period, that 1-year period, which the landlord said tenant delayed in vacating, which again, landlord acknowledged at the hearing that the tenant could have been out in May of 2021 had it not insisted on this racking removal.
Doesn't the Rove affidavit say that even putting aside the racking, they weren't out until the end of June?
So when they got the notice of termination, right to possession, they were prepared to vacate by May of 2021. My understanding is that through the give and take of to the tenant, you need to remove this racking, it delayed their actual removal of their personal possessions. So yes, Mr. Rowe testified that their personal stuff, the textile stuff, the inventory got out at the end of May of 2020.
And wasn't there testimony that even at the end of November, there was stuff left?
That's not my understanding, Your Honor. What we have,
During my visit on December 7th, I observed leftover wooden shelving from the racking that had been removed. There were fabric samples and fabric sample books. It says three, were cardboard boxes. There were general and audible left.
yeah,
General office items left in a few of the offices.
I wouldn't take issue with Mr. Easterday's observations. He was a credible witness. My suggestion to you is that both the landlord and the tenant agreed they could be out in May of 2021. Even at the hearing, Mr. Malamet said, yes, they could have been out in May of 21 if it were not for this racking removal. So to see a pallet of some leftover things, sure. They got sidelined by this racking removal. It was a disassembly segued into a full demolition. It was that involved, and it cost extraordinary expense, resources, and time. And again, it wasn't called for under the lease. So we've got this bucket of damage, which is in the hundreds of thousands of dollars when you consider the racking removal, which was an as-is condition at lease inception, when you consider the paint, when you consider the concrete and the paving and a slew of other.
Okay, but it did seem like your client or the tenant had obligations for maintenance.
The tenant had obligations to maintain the premises in good condition and to turn them over as they found them. That's what they did. They leased these premises in an as-is condition, which included the racking that belonged to the landlord. And so they had no obligation to remove that racking. So the only obligation...
But just to get away from the racking for a minute.
Yes.
Did they have an obligation to keep the paint up on the exterior?
So they would say that they kept the paint up, that there was no deterioration in that. And what we know by the record...
You didn't answer Justice Henry's question. Did they have the obligation with respect to the painting?
They had an obligation to maintain the property in the condition in which they found it. So if paint, for example, had peeled off or was clearly thinning or was a problem in an area, they would have needed to repair that and fix that.
They being
They being the tenant, and by extension, the charge to... But here's where we are in this case. We have Mr. Malamet, who's never been to the property. We have Mr. Easterday, who had never seen the before condition of this. We have no evidence of the before-after at this property of any kind. And so we don't even have an after look at what the landlord believed were the issues, because the landlord didn't invite an inspection. The landlord didn't provide any scopes of repair. The landlord didn't include the tenant in a thing. And we know, as to the expenses which might be properly charged, Judge Henry, we know by Mr. Malamet that they made no effort to relet. So the reletting expenses under the lease don't even apply. So tenant inducements, broker fees, they made no effort to find a broker. They made no effort to look into, what the conditions were, the climate for reletting was in Gaffney, South Carolina, because they knew they didn't want the property as is. They knew
Okay,
they
so
wanted...
but assuming for the minute that they can get liquidated damages, what do you agree would have been proper liquidated damages? What amount? You've given us this chart on page 34 of your brief, but you sort of seem to want to cross some items off of it, but you don't give us an alternative calculation.
So in my prayer, I suggest a couple of alternatives depending on how this court views the evidence. Does the court need more evidence on X, Y, Z, or, did the tenant or landlord need to do X? So this case could be remanded for further hearing on the issue of damages based on this court's guidance, or...
Well, what would you have us cross off on page 34?
Certainly. You just... So the South Carolina judgment is appropriate. Tenant defaulted, no question about that. We would take off April 2021 to March 22 rent and all of the incidentals with it.
April 2021, or would you start in May 2021 when you say that the tenant could have been out?
Well, I'm working with the lower court's order and the damage chart submitted.
Right,
I think it's fair, in answer to your question, to assign a month or two to May 2021, where the parties acknowledged the tenant could have been out.
Assume, strictly arguendo, just hypothetically, that we were to agree with you that the May 2021 to March 2022 rent and additional rent was, the judge was incorrect in assessing that. If that were the case, would the liquidated damages number below 656,718.72 be correct and fair in your view?
I think it would be, but I also think it's within this court's discretion to strike it if it deems it a penalty and so grossly disproportionate to actual damage. So that is an open issue for this court. But getting back to Judge Henry's question.
Your time is up, and I'm going to let you answer Justice Henry's question, and we may have an additional question for you. Go ahead.
Thank you, Your Honor. We think all of the repairs and cleanup need to go. None of them are called for by the terms of the lease. We point out in our briefing the distinction between reletting expenses, which we think is fairly well defined in the lease, versus alterations and repairs, which is a choice that the landlord might make. Importantly, that subsection of the lease doesn't say that, you know, the tenant is relieved of its liability for being in default. It just says, it doesn't say that they should be charged for those items. And so that whole section, in our view, would come out. And of course, it's within the court's discretion to decide what appropriate collections.
I have one final question. You have a section in your brief on failure to mitigate damages. What time frame are you explicitly arguing wherein they failed to mitigate? What date to what date?
After the termination of
3/25/21 to when? That's the notice of termination. Sorry.
Sure. When they got out, so I would say May of 2022, when the parties agreed that the tenant could have vacated.
So your argument is they failed to mitigate from March 25th of 2021 to May of 22?
So certainly that would be convenient for me to say. I'm going to say May of 2022 when the tenant is out.
May of 2022 to when?
Continuing.
Date.
Well, until and unless they had charged an appropriate liquidated damage charge that did not swallow up this extra year of rent.
So just so we're clear, your argument on the failure to mitigate is it started on May, their obligation to mitigate, where they failed to do so, began in May of 2022. Is that correct?
That's correct, Your Honor.
Thank you. Justice Ditkoff, anything further? Justice Henry?
All set.
Okay. Thank you very much. We appreciate your argument. We'll hear from
James
counsel.
Hume for the appellee,
Mr. Hume.
STAG Industrial.
Thank you, and Mr. Green is with you, correct?
Yes, it's a pleasure to be here, and I appreciate the opportunity to appear pro hoc. The judgment should be affirmed. This is an unconditional guarantee of a 15-year commercial lease that was not set to expire until 2032, and that's a very important point because at the time it was terminated, it still had years to run. In excess of 10 years of rent that would be due. Notably, because of the guarantee and its waiver provisions, the defendant has waived defenses available to the tenant. For example, with respect to the racking, the tenant agreed to remove the racking. I don't think the guarantor now can come into court and say that was an error. They have to take their tenant's action as they found it, which was an agreement.
Yeah, why is that, though? I mean, why isn't that just governed by the terms of the lease?
Well, it was.
Just because the tenant agrees to do something later, I don't understand why the guarantor then is dragged along with that obligation.
Because the tenant agreed to that obligation, and the guarantor has unconditionally agreed to guarantee the obligations of the tenant, and the tenant agreed to that obligation of removing the racking.
Are you saying the tenant agreed to that in the lease, or are you saying the tenant agreed to that later?
We think the tenant did agree to it in the lease, that it was not a real estate fixture. The racking was what would be called a trade fixture, and the lease clearly gave the landlord the right to require that the tenant remove fixtures and other similar equipment at the end of when the lease terminated, and that was the right the landlord exercised.
You didn't recover the racking expenses, right?
No, because the tenant removed the racking, correct. We did recover damages occurred by the removal. For example, the removal injured, damaged the sprinkler system, and there was a repair cost on that. I will say that there was only evidence from STAG before the court, which the court found the 2 STAG witnesses to be credible, and
Right, but he raises the point that there was no evidence before the judge below of the condition of the property before. So that, means you can't prove they needed to do any of the extensive repairs that are charged.
Justice Henry, the lease gave the landlord the right to require the tenant to remove equipment and fixtures. So the condition of the property before was really, on that perspective, irrelevant. And there was evidence that
But I'm not talking about that. If you look at his brief, there's all these repair and cleanup charges, and if there's no evidence before the court of conditions before, then how do we know what standard the landlord is bringing things to?
Well,
I mean, this is not completely applicable, but here, if you don't have a statement of conditions, say for a residential lease, then the landlord is pretty much out of luck.
the tenant was required to maintain the property and the equipment in good working repair and order, and the testimony was that these items were not in good order and they were not repaired. They were required to maintain and repair, and the judge found that the landlord had acted reasonably and that the items there, and it's right in the opinion, were ones that required to be repaired or the maintenance was deficient and required to be maintained, and all of the expenses awarded by the court were under, for this category, under that repair and maintain obligation that the lease imposed. So again, even if the condition originally was really irrelevant because the testimony was that the property was not in good condition and repair. I think on liquidated damages, the landlord or the guarantor has missed the way this lease worked. And like many commercial leases, when it was terminated in March of 2021, it did not end the obligation to pay rent, and rent continued to accrue. And in fact, the court also made the factual finding that the tenant did not vacate until November 2021. That was the evidence and a factual finding made by the trial court. It was at that point then that the landlord re-entered and attempted to do these repairs, to do the maintenance, to bring the property up to relatable condition, which it did, and then it elected the liquidated damages remedy a year later in March of 2022. And under the lease, there were 2 different formulas for liquidated damages. One was the rent reserved under the lease, which, as I said, at that time was 10 years of rent, less the fair market value of what the rental would be and allowing for a vacancy period and reletting expenses. And the court found that that was another finding by the court, that that amount would be greater than what the other liquidated damages amount was, just 12 months of rent, because the tenant was facing, and the guarantor, potential for 10 years of rent reduced by the present value and whatever the fair market value would be of those premises. And
Are you aware of any South Carolina cases that you could point us to delineating the distinction under South Carolina law between an enforceable liquidated damages clause and a penalty?
I think we did cite that cases that hold that the parties are free to put in a liquidated damages remedy. I would suggest in this case there's not a hint of evidence that this was in any way disproportionate, and that's the point I was making. The 12 months of rent, when you have 10 years left on the lease, is going to be far less than the other alternative, which is the greater. So here the landlord chose, and as the court found, the lesser of the 2. So I don't think disproportionality is even a relevant consideration in this case because of the way the facts unfolded. Clearly there was no double counting because the rent that was accrued as of that time, both by the judgment and the unpaid rent from termination to the election of liquidated damages, was one item, and then there was 12 months of rent as the liquidated penalty.
Liquidated damages that were imposed in this case was basically the year of rent that was due in what year?
Well, there's the liquidated damage rent, which would be from March of 2022 through presumably March of of this year. And then there was the...
I didn't think that's how the clause worked. I thought it was the 12-month period following the date of termination, which would be March 25th, 2021.
Right, right.
Liquidated damages would be from March 25th, 2021 till March
Right.
24th, 2022, right?
And that's the measure of liquidated damages,
Yeah.
right. That's the way it was measured for that 12-month period.
You also recovered for that time directly.
Exactly, because that rent had been accrued and unpaid, right. And then there was the measure. As I said, the other alternative would have been to provide a calculation of the present value of the 10 years of rent remaining on the lease at the time, less the present value of the fair market rental. And that's really discussing just the measure of liquidated damages, not the period for it. Right, correct.
So in other words, you're saying that although the calculation requires you to look at March 25th, 2021 to March 24th, 2022 to determine what the amount is for liquidated damages, that is not per se damages for that same time period.
Exactly. Just as had the landlord elected version 2, it would have looked at the balance of the lease term of 10 years, and there would have been a calculation there. As I say, that would be by no doubt substantially greater at this point in time.
I had some confusion with the term additional rent.
Yes.
It's defined in the lease as all sums payable by tenant under this lease other than annual fixed rent, which is the rent, the yearly and monthly rent pursuant to the breakdown in section 1.1. And then it doesn't define additional rent anywhere else. So what does additional rent really mean?
Additional rent is very commonly defined in commercial leases as every other item owed by a tenant. And the reason for that is if, for example, a tenant would not pay real estate taxes, would not pay a common area maintenance fee or some other item, it still allows the landlord to go to landlord-tenant court and get a summary eviction. And in order in most states, and I think South Carolina is the same, in order to use landlord-tenant court, the tenant must owe rent, not non-rent. So these commercial leases, and this
it's almost a euphemism.
Right. It defines everything the tenant owes as rent, so it can form the basis of a summary eviction action if that's the route the landlord would choose to go.
So are any of the damages that were awarded to your client in this case, did any of that represent additional rent?
Well, everything the tenant owes is additional rent under that definition.
So in other words, the April 2021 to March 22 additional rent, that's the property taxes, gas, wastewater removal, late charge, that's all additional rent?
They would be classified as additional rent under the lease, but as I say, that's really for the purpose of allowing them to be included in a summary eviction action.
But it looks to me like the additional rent isn't included in the liquidated damages number, is that right?
That's correct. It is not. It's
Just the term amount.
That's right. That's correct. Yeah, it says the doable for the 12-month period following termination. And there it was the 12 months of rent that was due. The other point that I think, and Mr. Otto made this argument, they've overlooked a specific waiver in the unconditional guarantee on the very first page in paragraph 2. It states, it's expressly understood and agreed that guarantor's liability hereunder shall be unaffected by, and then part 3, any delay by landlord in exercising any right under the lease or this guarantee, none of which shall ever operate as a waiver of such right. So I think, apart from the fact that the trial court found that the landlord had acted reasonably in this case, the argument that the landlord delayed just doesn't work because it's been waived expressly by the guarantee here. And in fact, the lease itself clearly says that the landlord may make this election of liquidated damages at any time, not required to do it when it's first can be elected. It could be elected at any time, and indeed, the way this lease is structured, we could be standing here today where the landlord had not yet elected liquidated damages and rent had been continuing to accrue.
Well, are there any boundaries on that, or are you contending that was completely unbounded?
It's unbounded, the way this lease. There is total discretion, and the law would enforce that in South Carolina, I believe.
That seems That seems rather disproportionate.
Well, it potentially could be disproportionate if you get close to the end of the lease term and you're trying to get an extra 12 months rent. But when you have 10 years left,
Well,
it's
but
certainly
don't we
not
have to determine whether it's grossly disproportionate at the time the lease is signed? So if you're telling me that there are circumstances in which it's grossly disproportionate, why doesn't that make it invalid?
Because the guarantee specifically waives any claim that the lease is invalid, which includes the liquidated damages. That's also in the guarantee. And I've been on the other side of these.
If there's an invalid liquidated damages clause, and then in a guarantee, you agree to pay the invalid liquidated damages clause, then the guarantee would be invalid as having an invalid liquidated damages clause,
I don't
wouldn't
think
it?
the law reflects that, Your Honor, under these unconditional guarantee cases. And I've been in Mr. Otto's position, and it's not a comfortable position to be in. When it waives defenses available attacking the lease, that's a waiver, and the guarantor cannot raise an invalidity of a lease provision as.
But I thought the whole point of the liquidated damages provision is here's something the parties agree to that is invalid. So I don't know how the parties agreeing to it can make it valid.
Well, we're not agreeing it's invalid. We think it was quite valid, that the standard measure would be the rent reserved under the lease, and in this case, it provided for a lesser but more certain amount that avoided the difficulties of proof. And here, and as I say, the judge specifically found that the liquidated damages selected here were the lesser of the two amounts that were potentially available under the lease, and therefore reasonable.
I have one final question. At page 14 of your brief, you have a list of what you reference as improperly deferred repairs and maintenance. So it lists $179,000 to repair a broken dock door, $127,000 for paving and concrete repairs, HVAC, electrical repairs, etc. My question for you is, assume there had been no breach or default. Let's assume this was a 5-year lease, there was no breach or default. And at the end of the lease, these items at this value existed for repair. Whose responsibility would that have been to pay for that?
The tenant would be responsible for making sure that the property were returned with working equipment and that the maintenance obligation had been satisfied and the repair obligation had been satisfied. And I don't think the fact that there was a default in this case affects that list here, that it would still be the tenant's responsibility to bring it back up. They don't obviously have to make it anything more than broom clean, but everything must be working in good repair. So we think that the trial court properly construed this, found the facts, and entered judgment. We ask it be affirmed.
See if there's any further questions from my colleagues.
Yeah, I just had one question, which was about the lease provision that carries over between pages 9 and 10. And you've got some bolded language on page 10 about the amount equal to the sum of the rent and all of their sums, other sums due, et cetera. But there's an or before that, part 3. And I'm trying to understand if you are applying the or if you are reading that as an and.
I'm wondering, I'm not following which or you're referring to, Justice
Do
Henry.
you see on page 10, right before the bolded language, there's a little 3, little I?
Oh, I see, yes, the or before the 3, yes.
Right. Are you reading that as an or are you reading that as an and?
I'm sure we're reading as an or.
So which one of those things are you claiming, 1 or 3? Because it seems like, I can't tell if you're claiming both.
Well,
But if it's an
but
or-
it's only an or between parts 2 or 3, because right before 2, you'll see plus either.
Okay. And so you're not claiming 2, you're claiming 3.
Exactly, and my point is that 2 would have been a much greater amount had we elected that.
1
And
plus
that's
2, 1 plus 3. You're claiming 1 and 3
1 plus
and no
3,
2.
yes, not the 2.
Not just 3.
Not just 3, 1 plus 3. One represents the rent that accrued from March of 21 through March of 22, when the election was made. We think we've tracked exactly what the lease provided, which is what Justice Krupp did.
Seeing no further questions, the case is submitted. Thank you both. Very helpful arguments, very well briefed. Thank you both.
Thank you.
Thank you, Your Honor.
Case is submitted. Calling our next case, docket 23P 48, MS v. N.F.S. So before we begin on this case, I will remind counsel that this case is partially impounded. So please refrain from using any names of any of the parties or referencing any impounded material whatsoever, okay? And we will hear first from counsel for the appellant.
Good morning, Your Honor. May it please the Court. Stephanie Curtin with Maureen McBrien on behalf of the husband appellant in this matter, Your Honor. We are here this morning because the husband is appealing from the issuance of a 209A abuse prevention order entered in the Hingham District Court on three separate bases. First, that the court abused its discretion in granting that order as it related to the wife because she failed to meet her burden of proof in establishing imminent fear of serious physical harm. Next, that the court abused its discretion to grant it as to the children because no independent basis existed in the record for extending that order to the parties' children. And lastly, because it violated the husband's due process rights by prohibiting the husband from presenting his case in a timely manner and depriving the husband of contact with his children for 22 days, Your Honors. Starting with my first argument, the wife here did not establish reasonable fear of imminent serious bodily harm.
So I have a preliminary background question. You're appealing from the decision made after is this the September 12th, 2022 hearing?
That's correct, Your Honor.
So at least in the version I have, the transcript ends suddenly. And I'm wondering, did the judge make findings of fact and rulings of law on the record in this case?
I believe there were further oral findings. I was not counsel at the 209A hearing, so we unfortunately don't have a record of what was said at the conclusion of the September 12th.
Did you or anyone else make any attempt to reconstruct the record or to supplement the record or file a motion under Mass Rule of Appellate Procedure 8 to supplement or reconstruct the record of any kind?
I did not, Your Honor.
Okay.
Can I ask?
That just makes it a little difficult for us in this sense. We don't know what the judge found on the record. And without those findings, we're sort of placed, we're supposed to give deference to the judge's rulings. And if we don't know what those rulings are, I'm not sure what kind of position that puts us in.
Understood. And there's certainly a great amount of deference that's given to the court in finding facts and in making credibility determinations in a 209A proceeding. Even without those explicit findings, though, particularly as it relates to the children in this case, you can see from the transcript of the evidence provided that there was no independent basis on the record for extension of that order to the children in particular.
So on October 6, 2022, the parties agree in probate court to temporary orders, presumably governing the contact and custody and visitation of the children. So why isn't this part of it moot now?
It's not because, Your Honor, there's case law to suggest that notwithstanding the subsequent amendment of a 209A order to allow for contact between a child and that child's parent, that doesn't extinguish the parent's right to establish that it wasn't lawfully issued in the first instance.
Issued at all, sure, but what about, is there anything that says that conditions that have been changed survive as far as mootness? I understand the order itself does not become moot just because it's expired or been terminated, but a particular condition in an order. What says that that doesn't become moot when that condition is gone?
I think that the case of SJ v. BH is illustrative on this point, Your Honor. That was a case akin to this one, where in that situation, the 209A order was subsequently amended to provide for contact between a parent against whom the 209A was issued and the party's children. It was subsequently amended to provide for that contact, but that case stood for the proposition that notwithstanding the amendment, the change in that condition, the defendant in that case had an ongoing right to establish that it was wrongfully issued in the first instance, Your Honor.
Do you have a published case that supports the proposition that you're making?
That's the one that's most on point, I would say, to address that proposition. And as I was mentioning, particularly as it relates to the parties.
Just to stick with this point, assuming you're right that there was a due process violation, and I'm not saying you are, but assuming you're right, what's the remedy?
Your Honor, I think in this issue, this particular instance, the issue with the due process right would have been the unlawful deprivation of contact for those initial 22 days where father was not permitted any opportunity to cross-examine mother before this order was extended, particularly to the party's children, given that fundamental right he has to their care and custody, Your Honor.
Right, but what do you want us to do? Because we can't give the time back.
That's correct, Your Honor. He would like to establish that was, I think this is more an academic piece of this at this juncture. We can't go back in time and give him 22 days with his children back, but that's particularly why we're here, given the fundamental interest in what he was truly deprived of by the lack of due process in this situation. Between August 15th and August 22nd, as the court's well aware from the record, there was a limited period of time at which the parties were able to present evidence to the court on the 209A, returning from the ex parte order, at which defendant also had no opportunity to present any evidence. Even after the court had noted on the record that they were running out of time, there was no decision made to allow defendant to have any opportunity to even engage in a limited cross-examination before that order extended not only to the wife but to the party's children for an additional 8 days. That, I would say, is violative of his due process rights. Particularly, we had no opportunity, and it was raised on the record.
But that's why I'm back to, assuming we agree, then what order is it you think we would issue? Do you think we would overturn the order, or because the order's been modified?
That's correct, Your Honor. It would be I think it would be a remand back to the district court with the notation and a finding that was violative of husband's due process right, particularly under those circumstances where I'm cognizant of congested court sessions and the need to hear emergency matters, but when a choice was made between a trial readiness conference and a recovery court hearing, rather than a return on a 209A that only one party had an opportunity to present evidence on, I think that implicates due process in a real way, particularly with the interest relative to the party's children in this case. Returning to what I was saying prior, the other issue with the judge's extension of the 209A order in this case was that there was no independent basis to extend it to the party's 3 children. It cannot be found in the record.
Can the judge consider that the husband left weapons unsecured and possible, narcotics available to the children unsecured? Is that sufficient to support an order?
I don't think that's sufficient to support the order, Your Honor. If you look at the cases that deal with firearms in this context, Diaz in particular and Noel N., those are situations where guns were not only present, but used as a tool to threaten the plaintiff in those cases. They were pictured on a video screen or used with an additional threat of harm. In one such case, Diaz in particular, there was a gun raised to the head of someone else with threats of violence. I don't think it can be argued that it was not a good exercise of judgment to leave the door unlocked to that room, but there isn't a nexus, which is required in a finding under 209A, between that unlocked storage space, and not only a concern about the lack of a lock, but physical harm and the use of force against the children. That's not present here, and for that reason, that alone would not justify the issuance, particularly where you don't have any allegations of abuse of the children, no witnessing of domestic violence.
What about when, after he attacked the wife, that he then wakes up the daughter and all the children are brought into the room while he's making tons of noise in the background? Must have been terrifying for those children.
So that situation, Your Honor, and I think that the court in this instance, when the judge made comments on the record in the first day of hearing that the daughter had witnessed that interaction and was afraid, that was in clear error. The testimony, if you look at the record, was that the daughter didn't witness it. She was upstairs. That's even in wife's brief that's filed today on page 15. Her fear wasn't of the father, and I think that's an important distinction to be made here. She was afraid that someone might be breaking in. This isn't akin to the cases where there's a fear of father, such as in Borla and in DRV DC, where there was a witnessing of an altercation between...
You don't think a judge could find that it would be scary to a child that their father, having already hurt their mother, is now banging around, causing noise, slamming the fridge door, banging chairs for, it seems like, quite some time?
I think if a child had witnessed that and saw their father doing it, that would certainly be grounds for that. They would be afraid that their dad might do something.
Right, so
That's
hearing
a
it,
different...
is the difference between hearing it and seeing it? Is that what you're telling me?
I think that there needs to be a fear connecting the child to the parent in that situation. Here, the fear was not of father. The fear was that maybe someone else was coming into the home. And that's the crux. If you look at Schechter, what we're looking at is trying to protect children from either a fear of imminent serious bodily harm from a parent or actual physical harm. If there's an amorphous fear that someone else might be in the home, unconnected to a parent, that's distinguishable. We have a different situation here. In fact,
but it is connected. I mean, that's the issue. It's the father's causing the fear, even if the child hasn't made that next leap to be afraid of the father.
But Schechter tells us, I think in that situation, that there needs to be not only a witnessing of potential argument between parents, but also as a result of that witnessing, a fear of that parent. Because at the end of the day, we need to return to the basis of a 209A, which is reasonable fear of imminent serious bodily harm or actual physical abuse, which I'm not talking so much about here since there were no references in the record to physical abuse of the children. Again, the only other basis, if we look at what Schechter is telling us about, would be if there were an inability to facilitate contact, for example, between the children without endangering
Schechter said the father has to rebut the presumption against his custody.
What was that?
Doesn't Schechter say the father has to rebut the presumption against his custody after engaging in abuse of either a parent or a child?
That's under 31A, Your Honor. It's slightly different than the standard under 209A for an abuse prevention order to extend, and it's dealing with the presumption of joint custody or parenting time in the context of the divorce. What the court was charged with in the Hingham District Court was simply the contact or no contact with the children. I think the other problem with this order seems to be an impermissible reliance on the probate court to resolve this issue without dealing with it in the first instance in the Hingham District Court. If we look at the references the judge made on the record, that this was just an emergency substitute until the parties could get to probate court, that the probate court would deal with reunification of the father and the children, that speaks to the problem of not addressing the question of whether there was really a basis, an independent basis in the record before the Hingham District Court to extend it. And we're told by cases like Smith v. Joyce that just because it might be a good idea or there's no harm in the moment, which it seems through the record to be what is conveyed by the court, that that's not a justification for issuance of a 209A, particularly in a case where you're dealing with a fundamental liberty interest.
Before you run out of time, let me ask you if you can explain to me how your appeal is timely.
Your Honor, the notice of appeal was properly issued after entry of the extension of the 209A in the Hingham District Court on September 12th.
But doesn't it have to be filed within 30 days of that?
That's correct, Your Honor.
It's filed on October 13th, appealing a September 12th order. It's stamped October 13th, 3:22 p.m.
I think it was docketed timely, Your Honor. Let me.
The docket also says it was filed on October 13th, as your friend pointed out.
It was dated earlier, Your Honor. I'm not sure why the docketing
It's
happened.
dated earlier. Did you mail it, or did you file it in hand?
I don't know, Your Honor.
Okay.
If there are no further questions, I would ask that the remedy in this case be that the order be vacated as it relates to the party's children, and I'll rest on the remainder of my brief.
Let's make sure the panel has no further questions. Justice Henry?
No.
Justice Ditkoff? No? Thank you very much. We will now hear from counsel for the appellee.
Good morning, members of the panel. My name is Richard Novich, and I represent the appellee. I'll refer to her as MS. The trial court's decision below should be affirmed for two primary reasons. One, there's been no showing the trial court committed an abuse of discretion, and two, there have been no due process violations here. I'd like to begin with Justice Henry's question about what do we do in the event of a due process violation. And I would respectfully suggest that the remedy lay in Chapter 209, Section 3. To the extent that N.S. was interested in pursuing visitation with his children during the 22 days, his remedy lay with the probate court where he had already filed an action, and the doors to of that court were certainly open to him. The second thing that I'll address is, I believe, another question or comment that Your Honor, Justice Henry made relative to the children. And I think your question pertained to, is it sufficient if there were guns and narcotics in the house? Would that be sufficient? I'd take it one step further, Your Honor. There was unchallenged testimony that Mr. had not once or twice, but at least 2 or 3 times conceded that he had threatened to kill himself. While there's no evidence that that threat was made directly to the children or even in their presence, what I would say, and I would direct Your Honor's attention to the case of Constance C. versus Raymond R., and there's a footnote in there, I believe it's footnote 11, that specifically says that those types of threats, suicidal threats, are, quote, red flags of high lethality and domestic violence cases. When coupled with unsecured guns, when coupled with an admitted history of alcohol and drug use, I would suggest that under the circumstances, the trial court judge did the only sensible thing she could do. She didn't wait for the disaster to happen, and she extended the order to the children. Let me now back up, if I could, and address the primary issue, I think, in this case, which has to do with whether and to what extent the restraining order should be extended, or was it appropriately extended as to MS. The appellant focuses much of his energy on credibility challenges to MS during the proceedings below. However, the trial court judge was not required to credit NS's rationalizations or view of the case. And in fact, on the contrary, that the trial court can properly, in the exercise of her discretion, credit the testimony, the demeanor, the affidavit, and the documents that have been submitted in evidence in drawing her conclusions and making her decision. What is unclear in this case, and Your Honor, Justice Neyman highlighted at the beginning of the case, is what testimony did she find most significant to justify the extension of the restraining order? That much is not currently known, I believe. However, I think the evidence in the record does suggest that there are 2 independent bases to extend the restraining order here under 209A, Section 1. There's subsection A and subsection B. And under those provisions of the statute, there was evidence of both physical harm, yanking, grabbing, almost bringing her down the stairs, etc., caused by N.S. less than a month before the restraining order was sought. And B, there were words in conduct, also of N.S., within 2 or 3 days of the requested restraining order that gave rise to what I suggest were objectively reasonable fears of imminent serious physical harm. The subsidiary facts that support these conclusions are set forth in our brief, supported by record citations. Hopefully they're appropriate and clear record citations. I am not going to insult your honors by regurgitating those facts. Certainly I know you'll read them. I would, however, like to just draw your attention and address two matters if I could. First thing is context. Context in these cases is of critical importance, as I know all of you are aware. The context in which N.S's actions and words should be considered together and not in a vacuum. And all of these events, beginning on July 1st, going to July 8th, and July 31st, and what have you, took place over a span of roughly 4 weeks. During that 4-week time, there was revelations of infidelity during a marriage. There were questions about visitation with children. There were thoughts of suicide. There were other threats. There was a revelation of what had been previously secured guns. Now there are unsecured guns. There's ammunition on the floor, et cetera, et cetera. The second thing that I would like to highlight is, although N.S. didn't testify, he did submit a verified affidavit, which I think was exceptionally telling. The affidavit did two things. It either admitted most of the salient facts, or it certainly did not deny a lot of the salient facts. For instance, he admitted grabbing the wrist. He had a different opinion on why he did it and what happened as a result of it, but he admitted that action. He admitted to throwing the chair. He denied the significance of the throwing of the chair, but he admitted the chair. He didn't deny that there was some history of alcohol abuse, and he didn't deny the issue of hallucinogenic drug use. And it goes on. Bottom line, Your Honors, I know you'll read the briefs. There was no due process violation here, and I would direct your attention to the recent case, albeit an unpublished decision, of a panel of the court known as AD versus MD. I won't get into the facts or the rationale of that case, but I would strongly suggest that the decision and the holding in that case is both illustrative and dispenses with the argument on due process grounds. Absent any questions of the members of the panel, I would respectfully rest on my brief.
Seeing none, thank you both. Your clients have received very good representation, and the case is submitted. Thank you. Calling our final case, docket 22P688, Doe v. Sorb.
As always.
So before we begin, I'll remind counsel that this case is impounded. Please refrain from using any names or from referencing any impounded material. Attorney Burkholder.
Good afternoon, members of the panel. Fred Burkholder on behalf of Doe 17938. It's been a long morning. You folks have been through it. I know you read our briefs. My brother wrote a great brief as usual. The case really comes down to context. I was sitting there thinking, in arguments in the past before the Superior Court, I've had judges say to me, Fred, it's all about the index offense. What was it? When was it? How many of them was it? What happened? So what do we have here? We have one that was 20 years ago. It was heinous. Nobody's going to say that it wasn't. Did he admit to rape? Yes, he did during the counseling, albeit it was 20 years ago. He did his time. He comes out.
And more importantly, he's aged by this point.
He's now 65. He was 44 when that happened. He was drunk. He admitted it. He wasn't behaving well. We all know that. He didn't behave well before that.
I'm just
we all know that
suggesting
too.
Someone who commits a crime at 20 and is now 40 is very different than someone who commits a crime at 40 and is now 65.
That is true. But we have to look and see, even the hearing examiner's treatment of the factors, for instance, with regards to factors 11 and 12, there's an admission that the conduct that supports application of those factors is dated. The probation violations are dated. Everything is dated. He gets out of prison in December of 2015. What's he do? He immediately goes to seek personal counseling, sex offender counseling, he secures a stable home, and he even does some volunteer work. I'm going there, so believe me, I know where everybody wants to go. I'm going there.
Oh, no, your 15 minutes are yours, and we very much are paying attention and care about this case.
All right. He is now 65. No, I'm going there in that we all know what we want to talk about, which is he goes to see, at my, of course, motion, allowance of funds and the like, he goes to see Dr. Sala. He doesn't lie about what he's been doing. Dr. Sala saw the reports because I provided them. I know what was in those reports. I know that I wanted to document his physical condition. I also know that not consuming alcohol was not a condition of his probation. It is not illegal, and it was over 20 years ago that he had any type of substance abuse offense. Most importantly, in making the decision to provide those and submit them, was the fact that he hasn't done anything wrong since he got out from 2015 to the present. And that's one of the things that Dr. Sala really relies upon, and I think it's overlooked. He doesn't get himself in any trouble. He's performing very well in treatment. Dr. Pettigrew says you don't even need any additional counseling back in 2019, I believe. And he continues along as very well in a stable situation, doing well. When Dr. Sala asks him what his conduct was, he's honest. Do I wish that he wouldn't have said it? Of course I do. But the reality is he did. So here's the question. The question is that a risk, is solicitation of a prostitute a risk-enhancing factor, or isn't it? I've never read a study, and I've read all the studies that are in the regulations cited because I'm challenging them with regards to race and Latinos in another matter, so I had to read every one of them. I don't see that mentioned anywhere. I don't condone the behavior, but how does the hearing examiner look at it? The hearing examiner says he has demonstrated that the mitigating factors above were not sufficient strength to assist him in modulating his sexual impulses and managing his sexual behavior appropriately, as evidenced by him seeking out and paying a prostitute for sex within the last 6 months of probation. Now, the hearing examiner also says he didn't consider that conduct with regards to factor 10, whether or not his conduct, in violation of that factor should be applied. The hearing examiner applied that factor, and there it is. What the hearing examiner does not mention is he actually asked Dr. Sala, after all the testimony was done, my brother did a wonderful job of cross-examining him, he asked the doctor, he says, "Doctor, do you think that that's indicative of risk?" Not only does he consider it, he addresses it specifically with regards to the issue of risk, and he says, "No, I do not." Now, I don't have the burden of proof in this case. They do. And I haven't seen any evidence that says that is an indication of risk. It may be an indication of continued criminal conduct, but again, we have to go back and look at the factors that applied here. We don't have any high-risk factors. We certainly have an extra-familiar victim. I get it. Dated, of course. We certainly have the use of a telephone. Dated, of course.
What the examiner says is it shows that he has an active sex drive, unusual for someone of his age, and that he's not willing to abide by all the conditions of probation, evidenced by the fact of him committing a crime, albeit
I can't say anything with regards to the latter part of the question concerning conditions of probation, that absurd. But with regards to the consideration of his sex drive, that's addressed in Factor 30. I stand before this court many, 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 many times and am told the things that I want to talk about are covered by the regulations. So the same thing applies here. Factor 30 was given less than full weight despite his age 65 because that factor recognizes that the expression of sexual interest takes away from the mitigating effect. So that's covered. I want to talk about one more factor, and then I'm not going to go on too long. I want to talk about Factor 9, substance abuse. There's a whole lot of difference between substance abuse and substance use. A tremendous amount of difference. And how do you usually tell whether or not someone is abusing a substance versus using them is what occurs thereafter. And I go back to the hearing examiner's failure to consider the counselors, treatment professionals, and the query that says he's not been in any trouble. So what do we have here? We have a 65-year-old man who probably was lonely, shouldn't have solicited a prostitute, shouldn't have probably told anybody he was drinking, but the reality is, look at all the good things that he's done for himself. And I stand before you and I say, I guess he's destined to be a level 2 the rest of his life. Because I'm going to hear in 3 years when he comes back for reclassification, because I did the first thing, so I'm likely to be doing it from there on. I'm going to hear, well, 3 years ago he solicited a prostitute. Well, 3 years ago he drank. At what point are you done with the scarlet letter? After 20 years and all the things that he has done. Most importantly, folks, and this is the last thing I will say, has he committed another sex offense? An enumerated sex offense? This statute was designed and promulgated and advanced to protect the public from predatory violent sexual conduct. That hasn't happened in over 20 years in this case, and soliciting a prostitute may be stupid and immoral, but it's not that. I have nothing further.
Let me see if the panel has questions.
Thank you.
Thank you very much, counsel.
Good afternoon, Your Honors. May it please the Court. Christopher Bover on behalf of the Sex Offender Registry Board.
So, Attorney Bova, could you address first Attorney Burkholder's comment about, or argument, I should say, about there being a distinction between alcohol use and, substance use and substance abuse?
Sure.
And what the record does or doesn't support here in terms of the findings on Factor 9?
Absolutely. Factor 9, which is a risk-elevating factor under the regulations. The hearing examiner...
Given full weight here?
Yes. The hearing examiner certainly considered them, considered the factor. So once you have a substance abuse history, or once you have a sex offense that involved the use or abuse of alcohol or drugs, the factor applies in full. And the factor, as a historical factor, will apply in full unless you have circumstances before you that would warrant a reduction in the elevation of that factor, if that makes sense. Okay? So here, the hearing examiner is the fact finder. The hearing examiner has to look at the evidence as it's portrayed to him. And in this particular case, you have an individual who has a lengthy substance abuse history, who was under the influence of intoxicating liquors and or drugs at the time of the index sex offense, okay, who is currently used, and who has relapsed, by the way, as Dr. Slade testified, on multiple occasions. I think it's logical for the hearing examiner to have a concern that an individual with such a past history currently uses substances and drugs, regardless of whether or not they are legal. So if you're in treatment...
Is it drugs and alcohol, or legal drugs and alcohol, or was it just alcohol?
So the factor was applied because he had both, as I understand it, both a problem with alcohol and drugs. Although the drug of choice, if my memory serves me correct, historically it was cocaine, and currently he's using marijuana. Yes. So the drugs are different. However, an individual who is a former substance abuser currently using substances, I think the hearing examiner logically can make that reasonable determination that that factor does not get reduced elevating weight, and that he can apply that factor in full.
Is that a problem?
Go ahead.
Is that a problem in this sense? So a person who has, assumed this is true, over the last, let's say, 15 years has had 1 to 2 drinks per week and has smoked marijuana 3 times a year, let's say, and the factor's given full weight, and you have someone who is doing cocaine daily and binge drinking daily, and it's given full weight.
Well, there's certainly differences, obviously, in your examples, Your Honor. I think the problem that we have in this particular instance is the time. This gentleman served a lot of time incarcerated. He wasn't offense-free out in the community for the period of time that you discussed. And while my brother stood up and his first line was, well, it's all about the index sex offense, it's all about the index sex. Not necessarily the case in this particular case, because in reclassification hearings, as the SJC said, and I apologize because I forget the case off the top of my head, but you can't look at reclassifications in a vacuum. In this particular case, this offender was classified as level 2 3 years prior to his reclassification, just over 3 years. The Superior Court upheld it, this court upheld it, a panel of this court upheld it. So only 3 years later, he's seeking reclassification downward, saying, everything's changing in my life. Well, not necessarily, okay? While he had the hearing examiner here, did apply offense-free time in the community, he just got over that hump where you start to consider it.
Is offense-free time in the community 5 years here?
It was just over 5 years. At the time this decision was written, it was just over 5 years. So to answer your question, Justice Neyman, the example that you give where a gentleman has been substance abuse-free for many, many years, there have been no incidents, is much different than an individual who has a huge past of substance abuse, actually had disciplinary reports while incarcerated for substance abuse, and then still is using substances upon release. Now, granted, he hasn't done anything, okay, but the hearing examiner has the ability under the regulations, under the case law, to in fact consider that, and I think he did appropriately. Moving on to factor, I think it was factor 30 as well.
But before we get there, he argues that he participated in sex offender treatment at the treatment center and that the SJC has acknowledged that requires a waiver of confidentiality and an acceptance of responsibility. I was wondering what you say to that.
Sure. First of all, I believe in terms of the waiver and the acceptance of responsibility, a lot of that in terms of case law goes to the application of factor 24 with respect to waivers and confidential and whatnot. The hearing examiner didn't apply factor 24 in this particular case. With respect to factor 32, there are a lot of individuals who go forward in treatment who do not accept responsibility, who minimize responsibility. We see that all the time. So that doesn't prohibit the hearing examiner from taking away from that. And in light of the regulation as written, it's clear he was still undergoing treatment at the time that this hearing took place. Good for the offender, certainly. However, under the regulations as written, the hearing examiner does not have to give full weight to that mitigating factor because, in fact, he hasn't completed treatment and he was taking treatment as part of his probation. So as the factor was written, I would suggest there was no error of law committed by the hearing examiner with respect to that. My brother brought up factor 30. I would suggest that in this particular case, the regulation is clear, and I think the hearing examiner applied the mitigating factor appropriately, given it reduced weight, given the fact that this individual is soliciting a prostitute, which is breaking law. It's a violation of law. He didn't get caught, he didn't get charged, but we all know that it is, in fact, illegal in Massachusetts to solicit a prostitute for sex. So, again, under the regulation, because of this individual's age, he is showing a active sex drive. Dr. Soleil testified that he masturbated, I believe it was approximately 6 months before the hearing. He's soliciting prostitution. So in this particular case, I think the hearing examiner did the correct analysis for the application of factor 30. Which leads us to Dr. Soleil's expert testimony. In this particular case, I think based upon the case law as I outlined in my brief, there are numerous instances of panels in this court under the exact same circumstances that the hearing examiner outlined the reasons in his decision why he disagreed with the expert opinion. There were a variety of factors that he disagreed with the application of the weight of those factors, and thus I would suggest there is no error in the analysis that the hearing examiner did with respect to Dr. Soleil's testimony. With that in mind, unless there's any other questions from the panel, I would rest on the remainder of my brief.
Seeing none, thank you. We appreciate the arguments and the comprehensive briefing by both parties. Thank you. The
Thank you,
case is
Your Honor.
submitted. I'd like to thank our clerks and Court Officer Spatty. That
Yes, thank you,
concludes our
Madam Clerk.
sitting.
All right,